Hey guys, I was in here and I thought, hey, maybe I should go down to the courthouse. Hey Denidra, I thought maybe I should go down to the courthouse and see what's up. You know, drive down there as I have the live feed on. Maybe I see myself down there. I'm just joking. I'm just joking. Let me show y'all what's going on in the courthouse with the It's so funny. As soon as I said, I'm gonna start doing this case, all of a sudden I see everything about it, right? Isn't that funny? This is it. They look at the camera, got it all at the bottom. There go Gunner. Young Thug. There go Young Thug. There you go. Y'all see him? They have it muted right now. They have it muted. Let's see. A lot of them in there. It's a lot of room too in that courtroom. Not that many people in the courtroom. He is. They have a rule, Miss Pat, that they can't show the certain faces in it. Because when I was going to go request my credentials for January, they have a lot of rules that I was reading about having. They'll allow you have your phone and stuff, but you have to not show certain things. Because I was putting in for my form because I'll be there in January when the trials start. This is like an emergency hearing, I think. Because Ghana yesterday got did the plea deal and he's getting out. Yeah. It's not me that has it turned down. It's the person who's doing the videoing is got it turned down. Let me see if I know any of the police officers in here. See if I see any of the police officers and see if I know any of them. Hmm. See if I wish I knew they were going to be down there, I would have went there this morning. Because if I decide to go down there now, it's going to take me a little while to get down there. So I was like, no. Ruby funny. She said it was Young Thug did it, not Jeffrey. Yeah. Free Jeffrey. So we're gonna see what happens now. Let me make this. Let's see. Let me put myself in the corner right here. Yeah. That looks cute, right? I look cute in the corner here. Let's see if we can make it over here. Oh, we missed him. Oh, we missed him. Why does this thing go out on me? Oh, goes out every time I try to get an order. It goes out on me. Yeah, they're finally back in court. Good afternoon, everybody. We're doing a watch. Welcome back. I was thinking about going down there, but then I was like, I gotta find parking. I gotta do this. I should have been prepared for it, you know. All right, let me make it bigger over here on this side here. See if we can make it a little bigger. I'm on the bottom. Yeah. Look at all the police officers back there. Oh, somebody's coming out with an orange suit on. Did you see the guy with the orange suit? Orange jail suit. Look at the officer with his phone, playing with his phone. Look at him. Look at the other one just picked up his phone. Mm-hmm. Seems like they're not even starting. Let's see. Maybe I should turn on my thing so y'all guys can see me on the side. Hey, hey, people. We're here to watch this hearing. As you guys know, that Gunner yesterday did a plea deal, and I was reading some of the language that was on that plea agreement. Let me go get that so I can read it to you guys while we wait. Hold on. All right, let's see. Okay, hold on. Someone's saying that if somebody gets freed like that on a racketeering case like that, most likely they have been an informant or a person who gave other people away. But in his plea agreement, Gunner said Kitchen, in exchange for his plea agreement, he will not serve any prison time. The plea deal sentenced him for 5 years with 1 year to serve in prison, and that time was commuted to time served, and the balance was suspended. He will need to complete 500 hours of community service, with 350 of those hours speaking to young men and women in the community about the danger of gang and gang violence. The entire sentence will be terminated after he completes his community service. Fulton Court Supreme Court Judge, Chief Judge Uriel Glanville also ruled that he is not to have any contact with his co-defendants. They said if called by any party in this case, he must testify truthfully, but can also reserve the right to invoke his Fifth Amendment rights. In a statement, Ghana did not admit guilt or claim he was guilty, pleading guilty in the best of the interests, in the best of his interests. When I became an affiliate of YSL in 2016, I did not consider it a gang, more like a group of people from Metro Atlanta who had common interests in artistic aspiration. My focus of YSL was entertainment, rap artists who wrote and performed music that exaggerated and glorified urban life in the Black community. While I have agreed to always be truthful, I want to make it perfectly clear that I have not made any statement, have not been interviewed, and have not cooperated, have not agreed to testify or be witness to for or against any party in the case, and have absolutely no intention of being involved in the trial process in any way. I have chosen to end my own RICO case with an Alford plea and end my personal ordeal by publicly acknowledging my association with YSL. An Alford plea is, in my case, in the entry of the guilty plea to the one charge against me, which is in my best interest, while at the same time maintaining my innocence towards the same charge. I love and cherish my association with YSL Music, and will always will. And I look at this as an opportunity to give back to my community and educate young men and women that gangs and violence only lead to destruction. Y'all hear that? Around 5 p.m., Kitchen walked out of the Fulton County Jail and into an SUV waiting for him outside. Prosecutor claims William is a founder of the alleged street gang YSL. The indictment also gives detailed account of various violent crimes alleged members of YSL are accused of. The documents, social media posts, and rap lyrics by Williams that reference YSL. The RICO trial for all defendants was scheduled to start after the first of the year. Okay, now this is the Alford plea, what it is. I'm going to tell y'all exactly what it is while we wait on these people to come on in. All right, what is Alford plea? An Alford plea, also sometimes known as the Kennedy Alford plea, Alford doctrine. Oh, they took it off? Oh, I thought they took it off. Okay. What was I reading? Alford guilty plea, Alford doctrine, and best interest plea is a type of guilty plea in criminal court that gives weight to evidence. It allows a defendant to continue to assess their innocence and not admit to criminal act, while conceding the evidence against them would likely lead to a conviction. The plea also allowed the defendant to skip a trial and just accept the consequences associated with a guilty plea. This plea is unlike a nolo contrary plea in that can be used, but no, that I can be, why I say I, it's supposed to be it, that it can be used against a defendant in civil cases in future court proceedings. Okay, it can be used in, okay. So kitchen, where is he going, giving back to the community, but because he's a snitch? He admitted that he was in a gang. Yeah, he did. Let me read those part too. Let me go into that part of it. Now I want to see his paperwork. Paperwork. That sucks. Why are they still not saying anything? Why is it still muted? The judge not back yet? Okay, here they come. They all coming back in now. Here they come. Here come the judge. Here they come. They all coming back into the courtroom. Here come the judge. There he is. All right, I'm about to mute myself because the judge is about to talk, okay? All right, good people, I'm about to mute. Oh, yeah, he's a black judge. Majority of the judge in Fulton County are black. But that doesn't mean they're nice. They're harsh. Hey, Miss London. Oh, there go the other defendant. There's not that many people in the court, Miss Lady Coach. Ain't nobody in the court. See how the court is pretty empty. Just the front of the court, it looks busy. But it's mostly nobody in the court. Nobody like going down there. I should have went down there. I would have got in. Here you go. Here it goes. It could have judge. Unmute it. Unmute it, people. Unmute us. Is the news people gonna unmute us? Now they're gonna make me want to go down there myself because they're muting us. Why don't they unmute us? Yeah, they still got us muted. What the heck? Why they got us muted? Do I have to go down to the courthouse? Y'all. Why is it muted? What the heck? Oh, really, people? They're just gonna have us muted like that, huh? They're just gonna mute us like that, y'all. Really? Lady Coach, I should go down there because they're talking and we can't hear them. What the heck? They are talking and we cannot hear them. This is crazy. What the heck is going on? Why have a news conference? I mean, why have it on here and you're not playing it?
Hear me? You can hear
Okay, now this isn't in. Oh my God, why they have us muted? Yeah, I'm tempted to go down there. I'm serious. I'm tempted, but the thing is, if I go down there, by the time I get down there, everything they said is gone. Ruby, he can't hear it either. Lead attorney can't hear it either. There's no sound on his because he's listening to the same thing. Ruby, you know what? Y'all making me want to go down there downtown to the courthouse. I want to go down there to the courthouse because they got me so on mute. Ah. I need to go down to the courthouse. Oh my God. Y'all can watch the thing and I'll write the notes. They did this crap on purpose, y'all. They did this crap. Maybe that's what the judge told them. You could do audio, but you could do visual, you can't do audio. Hold on, let me go to Twitter and see if who's in there and then they could tell us. Let's see what the note says on Twitter. That is so dirty, yeah. They don't want us to hear it. Oh my God, they don't want us to hear it. This sucks. No, that wasn't it. I was listening to another one. I know that wasn't it. I'm trying to find another station. I know another station that's supposed to be there, but they don't have sound either. Somebody tell him unmute the damn mic.
Hello, and thank you for joining us here at the First Desk. I'm Maria Moreau. We are.
Sorry, y'all. This is crazy. I think the judge ordered them not to play it on live because the other station is playing it as well, but they have theirs muted as well. So the judge is asking this to be muted. Oh well. Everybody reading lips?
Important is that
There it is.
it's a pretrial statute. That's not to be confused with 17-5-54, which is the return of property after a trial. So the reason that the 17-530 statute is particularly important is that, and I'll read it for you all. I know you all probably know this, but just so it's in the record. A defendant aggrieved by unlawful search and seizure may move the court for the return of property in the possession of which is not otherwise unlawful. So that means, of course, if it's contraband, other drugs, weapons, or other things that wouldn't ordinarily be subject to being returned, and to suppress as evidence anything obtained on the grounds that the search and seizure without a warrant was illegal, or the search and seizure with a warrant was illegal because the warrant is insufficient on its face, there wasn't probable cause for the issuance of the warrant, or the warrant was illegally executed. The motion shall be in writing, which that one was. State facts showing the search and seizure were unlawful, which it was. The judge shall receive evidence outside the presence of the jury on any issue of fact necessary to determine the motion, and the burden of proving that the search and seizure were unlawful shall be on the state. If the motion is granted, the property shall be restored unless otherwise subject to lawful detention. Lawful detention would be contraband, of course, and it shall not be admissible, mandatory, shall not be admissible in evidence against the movement in any trial. The motion shall be made only before a court with jurisdiction to try the offense. If a criminal accusation is filed or an indictment or special presentment is returned by a grand jury, the motion shall be made only before the court which the accusation, indictment, or special presentment is filed and pending. The last time that we were in court, the court, Mr. Steele, I think we admitted for the court's consideration D1 through 10. Within those documents was the order Judge Newkirk entered. Can I have those, Christina? Do you have those? Do you have those ones? Are they up here? Okay, hold on a second. Okay, hold on. No, that's it. Thank you. All right. All right. D1 was the accusation that was filed in this case, and that was related to the possession of marijuana charge. D2 was the motion to suppress any and all evidence located from the defendant's home. D3 was the supplemental motion to suppress any and all evidence located from the defendant's home. D4 was the order granting supplemental motion to suppress any and all evidence. And it reads as follows. After hearing testimony, a stipulation of testimony, and argument from the parties on Monday, April the 3rd, 2017, this court hereby grants defendant's supplemental motion to suppress any and all evidence located from the defendant's home. Based on this ruling, the evidence located in defendant Williams' home is subject to the above referenced accusation number 16 SC1, and there are 6 fours. Specifically, that just over an ounce of marijuana, it is hereby suppressed and cannot be used in evidence by the prosecution in the trial of Jeffrey Williams, signed by Henry Newkirk on the 10th of April, 2017. There was a motion for reconsideration that was filed or accepted by the clerk's office on the 20th of April of 2017. There was an order, that was D5. D6 is there was an order by Judge Newkirk entered on the 24th of April, 2017. The order, it reads as follows. The court having read and considered the state's motion for reconsideration, the same is hereby denied. D7 is a motion for null pros on the same case where Mr. Steele filed a request to have the accusation null pros. D8 is the dismissal for want of prosecution. When the case was called for trial, the state was unable to proceed, and Judge Newkirk has the following reason: the motion to suppress was granted, and he granted the motion to suppress, and that was the 3rd of April, 2017. There is a exhibit from our last hearing on the 17th, D9, which is a letter that was written by Mr. Steele to Mr. Charlie Bailey, Esquire, May 17th of 2018. Read the State of Georgia versus Jeffrey Williams, accusation 16 SC1 444444. Dear Mr. Bailey, I hope all is well with you and your family. I'm writing you to pursuant to my representation of Mr. Jeffrey Williams in the above referenced case. As known, the Honorable Court suppressed all the evidence in the case, was null pros, and prosecution is ceased. Mr. Williams has been attempting to obtain his property that is lawfully his concerning the above referenced case. The City of Atlanta is not releasing the same, as they still have the same marked as evidence, according to Mr. Williams' father. Could you please assist in having the property released to the lawful possession of Mr. Williams or his designee? Please call upon receipt to discuss the above. I look forward to speaking with you soon. Signed, sincerely, Brian Steele. Copies to the two Williams, one being the defendant, one being the senior, his father. D10 is these warrant for search and seizure. And those were the 10 exhibits that were admitted for the court's consideration on the motion on the 17th of November. So the court's concern is that while you all, the state that is, think that Judge Newkirk just specifically excluded the marijuana, he did, but the legal premise behind it would be fruit of the poisonous tree. Anything that was taken in that house at that point in time would be subject to being suppressed. And that's the first thing I'm going to let you all address. The second thing that would be of note is that under 17-5-30, this property was requested to be returned. And the statute's pretty clear, shall not be used in a future criminal prosecution. That is different than the return of property statute during trial 17-5-54. So, yeah, that's why I preface this. I've had an opportunity to take a look at Judge Newkirk's transcript, which will also be included for purpose of the record, is the next court exhibit from the 3rd of April of 2017. So with that, Ms. Love, what say you and your colleagues?
Yes, Your Honor. First of all, Your Honor, understanding the court's review of the transcript, I want to point out that in ruling on evidence that pertained to the possession of marijuana charge that Mr. Williams faced in that indictment, the court specifically, during the course of the proceedings, clarified during an exchange with the prosecutor, he is only seeking to suppress the marijuana.
I agree with you that, but the legal premise would still hold on anything that was taken in that home by a search warrant. You had an arrest warrant issue, and then you had a search warrant issue. So if Mr. Steele challenged the arrest to begin with, the warrant or copies of the arrest warrant and the warrant under Baez, versus the state, which is a 206 Georgia 552, which he cited at that point in time. That would make it so that anything else in the house that was taken would have been subject to being suppressed. Mr. Steele amended his motion. He asked for everything.
Damn it, they mute us again. What the heck? What's wrong with that idiot? Unmute us. What is wrong with them? Oh, Lord have mercy. They keep playing with us, y'all. They keep playing with us with this mutant crap. keep on. So Tiffany, it was my comment on the hair. I'm sorry. I didn't mean to talk about your perm. Please let us hear it. Please let us come back and hear it. We don't want to hear the. I'm sorry. Oh my God. Maybe they saying something about the address. Maybe that's why they muted us. This is crazy. They muting us again, y'all. Yep, they need a meeting with the supervisor. Oh my God. This was getting good. They decided to mute us, y'all. They muted everybody because I'm looking at Channel 2 News. And they muting them on Channel 2 News too. Look. See now, Channel 2 News, they muting them too. Look. See? They muting them too. Yeah. Somebody said, "Where's Fox when you need him?" Because CBS and Live 11 Alive is not. There's no sound. It's literally happened after you basically said her hair was nappy. But we got my sister with the straight hair up here, so I don't. That part of the transcript would be blacked out. Lordy, Claudia. I was trying to see who else got it going. She's muted too. Look at it. She's muted. Look at she's muted. Muted on this. They don't want us to be great. They don't want us to hear. Let's see who else is playing it.
Antonio, here we go. Look. Why the out for plea, Gunna?
He's not making any statements right now, guys. Thank you.
Anything you can say for fans or
No,
supporters?
we have a. My head's spinning. Haven't slept in a while. We had a press release that I think we issued.
Thank
Do y'all have a copy?
Yep.
Okay, thank you. Thank you.
So I'm looking at other things right now because they're getting on my nerve.
What was your official?
Y'all, they just getting on my nerve now. They're getting on my nerve. They just won't let us be great, y'all. Muddy Water said, "Who braided Jeffrey's head?" Muddy Water. Why you ask that question? We don't know who braided his hair. Oh my goodness. Guys, we're listening to those who are coming in right now. We're listening to the hearing, but for some strange reason, they have muted us again. Keem Prince, don't laugh. Oh, Miss Fat, stop it. Miss Fat says Shim braided it. Okay, can we hear his attorney? Come on now, I want to hear his attorney. Steele is good. Muddy Waters, they got some male beauticians in there. Muddy Waters, they got some male beautician in the jail. Just like I had a male hairdresser before. Several times I've had a male hairdresser. Oh, they got the video. Look at them. They got the video of look at what is he grabbing his ding ding? What the heck? Y'all see the video they watching? Y'all see the video? You see the video, y'all? You see the video they're watching? Somebody grabbing their ding ding. He needs some Vaseline on his lip. That guy over there sitting next to him looked like it could be his relative. Look at their eyes. Their eyes kind of look alike. You know what, Tiffany? Tiffany says, "Oh, courts, we apologize on the behalf of the channel." She wasn't actually referring to attorney needing a perm. It was someone else. Can we hear now? Thanks. Oh. Oh, yeah, he do look mad, don't he? They took the earring that was in his lip out, I see. Remember the earring he used to have? Yeah, his hair is done fresh. Muddy Water, you need to go sit in the corner. Muddy Water, you gonna cause us not to have. Okay, they're gonna put the speaker on. They're gonna put the thing back on again. Hold on, let's see. There they go. They're gonna put it back on.
Okay, all right, Mr. Steele, sorry about that. Okay, so I do have the transcript from April the 3rd of 2017 with, and I've labeled it as the court's next exhibit in order. Court's 2 for purposes of this motion.
So, Your Honor, if I may go backwards for a second, if that's okay, I'd like to just first discuss and take care of State versus Alford. It's ALFORD, and it's 347 Georgia Appeal 208. It's a 2018 case that the Honorable Prosecutor has cited to this court. It's in Division 3 that the prosecution is relying upon, and it is wholly inapposite to what we're dealing with here. What we're dealing with here in Court's Exhibit number 2, which is the transcript from April 3, 2017, has nothing to do with what happened in Alford. In Alford, Mr. Alford is a passenger in a vehicle. The car gets stopped. Law enforcement officers see open containers and they smell marijuana as they approach the car. The officers then ask Mr. Alford, is that your backpack at your feet? And the answer is yes. And there's contraband, there's drugs inside the backpack. Mr. Alford is arrested and he's prosecuted for that. The Honorable Trial Court had a pretrial motion to suppress. And the state of Georgia was on notice that Mr. Alford, just like the Honorable Mr. Williams, challenged the actual arrest. And the state of Georgia did not bring in a certified copy of a county ordinance saying that a person can't have an open container in a car. Because of that, the trial court granted the motion to suppress. The state of Georgia appealed. What happened in the Court of Appeals was as follows. The Court of Appeals said, that's exactly right. Without introducing the certified copy of the county ordinance, there was no arrest for that purpose. But what the court then went on to hold is, however, when law enforcement officers lawfully walked up to the car, they smelled marijuana. And the odor of marijuana in the state of Georgia is a reason, probable cause, to search the car under the automobile exception. And because the automobile exception kicked in, it didn't matter that there was no certified copy of the county ordinance, and the Honorable Court of Appeals of Georgia found that the odor of marijuana was sufficient probable cause. The police then could search the car under the automobile exception. The backpack then, therefore, should be searched. The contraband inside the backpack should not. In Court's Exhibit number 2, so Alford is like a waste. Respectful, I don't mean to be rude. It is just not even close to what we have here.
Can I hijack for just a second, Mr. Steele?
Of course.
We're going backwards. We should be going forwards. That, I agree with you with at the status of your hearing in front of Judge Newkirk, the issues involving the search warrant, the arrest warrant, the search warrant, and these issues would have been, it's a snapshot in time. Since you filed another motion to suppress, the state now is willing to at least present forth evidence to show that the arrest warrant, the search warrant, and the seizure of these particular items, that there is a basis, because we've gone forward and it's another case. So can you address that for me? Because I don't believe that I have to look at it from my foxhole, because this evidence is related to, you filed a motion to suppress in this case. So I can't rely totally upon what Judge Newkirk has indicated. And also, this case was never appealed, so there's no really appellate ruling on this issue. So I would argue it's ripe to consider again.
I would respectfully disagree. I wish I could do that in every case that I don't win, that I can come in and do a second bite at the apple. This is the exact
But it's a
issue.
different case.
No, so then the state can just, I win a motion to suppress?
No, it's a different, okay, it's a different case That was just a possession of marijuana case. This is a RICO case, and they're arguing at this point in time, since you filed another motion to suppress, that we look at probable cause and the other things from the vantage point of 2022.
Your Honor, I filed a motion to suppress based upon the law of the case. It's a final order. It was not appealed by the state of Georgia. It is a final order. It doesn't matter. It didn't go up to the appellate court. And it is the same issue that's already been litigated between the same parties, Mr. Williams and the state of Georgia. They're still the state of Georgia. It is res judicata and it is collateral estoppel, and all that is in my motion to suppress. Also, it is not accurate to say that Judge Newkirk did not consider fruit of the poisonous tree. Judge Newkirk considered the following. My motions, which are in front of the court, the original motion and the supplemental motion, challenges everything that was taken from Mr. Williams' home.
Your motion to suppress is D2, and your supplemental motion is D3.
And it challenges everything that was done because the police unlawfully, as found by the Honorable Judge Newkirk, entered Mr. Williams' home. So what happens at our hearing, specifically at transcript page 18. This is on my cross-examination of the lead officer.
I'm with you.
Specifically, starting at line 5, or line 3. The answer is, yes, sir, I do believe there was an arrest warrant. I interrupted. I didn't mean to interrupt, but I interrupted. I said, I didn't mean to cut you off. The answer continues. That is what the warrant was for. Yes, sir. Then my question is, and that warrant was from a long time before. If you know, and if you don't know, we can get the information through someone else. Answer, I don't know the exact actual. I then asked, were you aware the warrant or the case was eventually dismissed? Answer, I'm not certain, sir. My question, so law enforcement officers do not have a search warrant, though at that time, this is simply an arrest warrant. Answer, correct. On page 33, which is what the state is trying to hijack, to use your word, Your Honor, this motions transcript and wrongly mislead the parties on what it says. The trial court, Honorable Judge Newkirk, on line 14 states, all right, no other evidence, brief argument. The Honorable Mr. Bailey, then District Attorney in Fulton County, said, Your Honor, the defendant has filed this motion through his attorney, Mr. Steele, challenging while seeking to suppress evidence in this case that was collected from Mr. Williams' home at the time. The basis of this motion is, and the Honorable Court interrupts, the only thing he's challenging is marijuana, which is what the state seeks. Mr. Bailey says on line 23, right. The basis of the motion, thank you, Judge, the basis of this motion is essentially that in the motion filed by the defense, that law enforcement officers did not have the right to enter the home, did not have the right to enter the home to effect the warrant. Going down to line 3, it's on page 34, continuing. Mr. Bailey, the district attorney, on page
Can I interrupt you a second?
of course.
IT's about to create a new secure Zoom link that's only for the attorneys. You're not to share the link. You understand me? Good? All right, thanks. Okay. I'm sorry, continue.
That's okay.
I apologize.
On page 3, 34, Your Honor, of Court's Exhibit 2, line 3. This is Mr. Bailey, the district attorney at that time, was senior assistant district attorney. On page 3 of the motion, it states, Mr. Williams was arrested on a DeKalb County warrant. However, law enforcement officers unlawfully entered and searched Mr. Williams' home, even though they were supposedly armed with an arrest warrant, and there was no need to search or even enter Mr. Williams' home in an effort to serve this alleged arrest warrant, as there was no lawful reason to force entering Mr. Williams' home. Then there are two parts here. And that's the long and short of it. Did they, meaning police, have the right to effect the arrest warrant? And what did they see once they got inside that would rise to probable cause? Then skipping, Your Honor, to line 21, same page 34. This is Mr. Bailey again. Normally, officers can't just walk into folks' homes. That is well established, but there is a carve out for affecting. Officers have reasonable belief the individuals inside. So it is not this way the state is saying that it's only somehow marijuana. I challenge the entry into Mr. Williams' home. When law enforcement went in home, they allegedly found marijuana, guns, other contraband, and that's when eventually the seizure of all of Mr. Williams' electronic devices that I've challenged, that should have been returned, I've challenged, cannot be used in this case. On page 35, the district attorney said at the end of line 1, Your Honor, or it's the middle of line 1, an arrest warrant found on probable cause implicitly carries with it the limited authority to enter a dwelling in which a suspect lives when there is reason to believe he is within.
Bam! There it
State
is,
is
right
saying
there.
the entry into Mr. Williams' home was unlawful. He has his constitutional rights violated. He's a victim. The
Go
court
on,
should say
attorney.
respectfully, no way, this would litigate it. On page 36, the district attorney continues. It's on line 10, Your Honor, and the parties. Now, were the facts that they knocked and he came to the door, and they, meaning the police, Your Honor,
Switching you
detained him,
around,
meaning Mr.
dude.
Williams, then Mr. Steele would be completely correct, and they could not enter the home. They affected the arrest warrant. Then
Bam!
skipping to line 19, Your Honor, page 36. So they have all clear
Know
lawful
your rights,
authority,
people.
talking about the
Know your
police, to
rights.
go
Just because you get
in to
arrested
effect
does not
the
give you
arrest
right to
warrant.
search your
And then
home.
we get to the
You need a
second point.
search warrant.
And it is in the same Wall case. Wall is W-A-L-L. It states on the last page, once inside the apartment, the law enforcement officers had the authority to seize marijuana that was in plain view. I challenge that law enforcement had no right to go into Mr. Williams' abode.
That's it.
And then the prosecutor on page 36, line 25 concludes, that is exactly what we have in this case. Once law enforcement is inside, they see marijuana on the coffee table in the master bedroom suite, and additionally marijuana on the nightstand in the master bedroom. And Detective Gaither further testified there were guns located in the living room. So that is, I challenged, I had a hearing, we won the hearing, it was a final judgment, not appealed.
Final
I'm
judgment,
not
Judge.
respectfully required to do it again so the state can bring their A game, lose, and then bring their A plus game and try to win before this court. That's
They
not the
lost.
way, I don't get to do that, ever.
But it wasn't appealed. I mean, there was, Judge Newkirk's ruling could have been appealed by the state or could have been appealed by you within 30 days of the entry of the order.
Don't do
Why would
that.
I appeal it?
Well, no, you wouldn't appeal it.
Don't
And the
do
state
that,
doesn't
Judge.
appeal. What does that
Don't do
mean?
that,
It
Judge.
becomes final. The court cannot amend that order. You'd be amending the finding between the same parties
Go ahead
on
on.
the same exact issue. They don't get the second, in the case law, it says second bite at the apple. Then, Your Honor, on page
Judge, learn the law.
38, line 14, this is the district attorney again.
We need that lawyer.
So
I need
it's
him.
just not an issue that makes any distinction or any difference. It's clear here that it's clear here they, meaning the police, had authority to go in to effect the arrest warrant because Mr. Williams wasn't outside the house and he didn't come to the door. Once inside, law enforcement saw illegal contraband drugs, that is probable cause to get a search warrant all day long in any jurisdiction in the state. Your Honor, the police had no right to enter. That ruling was made. I then say on page 39, of the same Court's Exhibit 2,
That's why you
line
don't
1,
let
I
them
get to
inside
speak.
your
The
house,
court
y'all.
gave me the
Don't let them
opportunity to
inside
speak.
your house unless they
I
have
said,
a
thank
search
you,
warrant.
Your Honor. Your Honor, we are traveling under, I'm assuming the court has
No
it. If not,
popo
we'll get you a
inside your
copy.
house.
There was a supplement to motion to suppress, and this is what I'm stressing, sir, the Honorable Judge Glanville. Any and all evidence located.
Oh, they mad at me because I said that? They muted us again. They muted us again, y'all. They muted us again. Dang. Tiffany, I gotta stay quiet. Where's she at? Tiffany,
And I stress this, Your Honor, all evidence must be suppressed. It is not the way you're being told by the Honorable District Attorney's Office. This was not about, oh, the judge only suppressed marijuana. That is just patently a intellectually incorrect way to interpret this. On page 39 of that same transcript, line 25, I continue. First, one, there is no certified copy or any copy of an arrest warrant in DeKalb County under Baez, which the court already spelled B-A-E-Z versus state. And then we get into that arrest warrant. And then I say on page 40, Your Honor, line 10 in the middle, is that if there is no arrest warrant, the police entry into, and I said, appellant's home was unlawful and his arrest would be unlawful. And then the fruits of the unlawful arrest may not be introduced into evidence. An arrest warrant was never part of the record below. An arrest warrant not put in evidence was not put in evidence while the witness testified or at any other time. The participants in the suppression hearing refer obscurely to the warrant, the warrant in the case. But there is no document to show that there is an arrest warrant. No judicial officer testified that he or she issued an arrest warrant. If the arrest warrant in existence, no reason whatsoever appears for the state's refusal to put it into evidence in the face of a demand. And I continued, I didn't write, I spoke, page 41, line 1. Mr. Williams demanded in paragraph 7 of the supplemental motion and challenge that there is an arrest warrant. If there's no arrest warrant introduced in the hearing, then we go down the road in kind of an outline. So if there's no arrest warrant before this honorable court, which there is not, then law enforcement officers, according to Sergeant Gaither, 30 or 35 law enforcement officers surrounding his home, Sergeant Gaither, which is Gaither, did not go into the home. However, law enforcement officers entered this home. This honorable court has no evidence that they entered lawfully. Supposedly, he goes into Mr. Williams' bedroom. Now Mr. Williams is outside. So my first issue is the initial entry without the arrest warrants vitiates everything coming afterwards. That was my argument. On page 42, line 12, I argued to the Honorable Judge Newkirk. So my issue, I said, right, period. So my issue before this honorable court is the first entry, obviously without the arrest warrant at this hearing, is unlawful. Then the second can't be saved by the second entry either, because that would be without lawful blessing. Same thing as unlawful search, the second one we're talking about. Then the search warrant issue, this would be my third issue. So first one, no arrest warrant. I am challenging, it is clear to everybody, including when you read the state's motion for reconsideration that I've already entered, Your Honor, at the last hearing, everyone knew I was arguing that the entry into Mr. Williams' home was unlawful, and therefore everything in that home could not be taken, should have been suppressed and returned to Mr. Williams. And the state's reliance on Alford, State versus Alford, the state's reliance on this narrow window that only the Honorable Judge Newkirk suppressed marijuana is frivolous. On page 43, starting line 4, I continued. But then when the court goes through and looks at the search warrant itself, The only way we would have probable cause in the search warrant is if the court finds that law enforcement officers on the day that this happened actually had the lawful right to go in the house and to observe, because everything else in that search warrant does not produce probable cause to search Mr. Williams' home. Then it continues on page 45. On line 4, at the end, I say in the middle of the sentence, nothing is attached showing that this arrest warrant was valid from DeKalb County. On line 40, page 46, on line 5, the next issue, Your Honor, that is asserted is that law enforcement officers entered Mr. Williams' home on the day that we're talking about. And I challenge that in the supplemental motion with the fact that it was read to this honorable court by the district attorney, supposedly armed with an arrest warrant, and there was no need to search or even enter Mr. Williams' home because I'm challenging the arrest warrant was not valid if there is an arrest warrant. And the last issue in the affidavit for the search warrant discusses items that were located by law enforcement officers during the search on the day that you heard about, which I would say is a fruit of the poisonous tree. So I have 3 issues. 1, there is no at all arrest warrant presented to this court. So under Baez, which I have a copy for the court, how can I challenge the arrest warrant? How can the court say it's a lawful arrest of Mr. Williams at his home without being armed with a certified copy of the arrest warrant? Therefore, and I stress this, Your Honor, everything thereafter falls as fruit of the poisonous tree. On page 47 of the transcript in courts number 2, on line 9, I continued. So the only thing we're left with is the unlawful entries into Mr. Williams' home, and I would ask the court, based upon that, suppress the evidence, grant the motion to suppress. Mr. Bailey then speaks on page 47, line 14, and going to line 18. At the last word, he says, this motion to suppress the search of a home that the defense is alleging is illegal. Nobody's talking about only marijuana. Mr. Bailey continues on page 48, in line 10 in the middle. The only 2 questions, Your Honor, are, did they have reason to believe Mr. Williams would be there, and so they could go into the house and get him? That's it. And then secondly, once they're in the house, did they see something that would give them probable cause to obtain a search warrant? Those are the 2 issues, not whether the arrest warrant out of DeKalb County was valid and whether the case was eventually dismissed or anything like that. The court then, on page 49, on line 6, says to the state, in which case you would have produced a copy of the arrest warrant. And Mr. Bailey says, right, which would have been a subject, I'm sure, of the suppression motion at that point. And then the Honorable Judge Newkirk said, well, it sounds like Mr. Steele made the arrest warrant a subject of this motion, also in a supplemental motion, which the court file does not have. What the prosecutor says, and that is the copy, the supplemental one. Again, he's not challenging the arrest in this case. He mentions something in there about DeKalb arrest warrant. If he wants, there's no need to challenge the DeKalb arrest warrant now because the case was dismissed. But there is a forum for doing that, and that may be what they did in the case. Maybe they challenged the arrest warrant in that case. On page 51 of courts number 2, the district attorney states on line 6, that doesn't mean that because there's not a certified copy of that arrest warrant that has any bearing at all on whether the entry and subsequent search of this house was proper. Everyone's talking, Your Honor, about the entry. That would be the state's argument in the case. At line 11, the Honorable Judge Newkirk said, all right, tell me again about Baez. I'm not familiar with it. What is the site? Is it Supreme Court or Georgia Supreme Court? I say Court of Appeals. I give the court the site. And then on line
Then on, sir, I
51.
51, okay.
Yes, sir.
Yep.
And then on line, the court asked me for a summation on Baez again, and I said, okay, that's on line 22. So it's a motion to suppress like we're dealing with here. Law enforcement officers have obtained a search warrant after an arrest warrant. So it's the same sequence here. Going on to page 52, Your Honor. Law enforcement officers utilize the arrest warrant. They call it several things, bench warrant, arrest warrant. And just like Mr. Williams, it was challenged whether it was a valid arrest warrant. The motion to suppress hearing goes forward. The prosecution doesn't put forth the arrest warrant. The Court of Appeals says without the arrest warrant, it is not in the record. We are not finding there was an arrest warrant. It was challenged, and they suppress the evidence and find it is a fruit of, since there's no basis in the record to have an arrest warrant, everything thereafter is unlawful. That's exactly what I think happened here. That's why I used the case. Why did I make the supplemental motion to suppress all evidence located from Mr. Williams' home? Your Honor, I was challenging everything. It is clear. And I'll get to the Judge Newkirk's order because it's not a fair reading of the order to say only the marijuana. That's not true. I didn't write that order, by the way. On page 52, line 23, I say, and I don't want to play games with anybody. I put it in its own paragraph. I made it a supplemental because I realized there was a problem with the arrest warrant. So I made paragraph 7 standing alone or standing on its own. And I wrote, moreover, law enforcement officers were not armed with a valid arrest warrant in DeKalb County at the time of entering Mr. Williams' home. And thus, and Your Honor, I'm stressing this, all evidence must be suppressed on page 53, lines 1 through 5. Then skipping to line 15, I again plead to the Honorable Judge Newkirk, the law should be followed in this case. And I say, but I guess it goes back to if the first arrest warrant is not before this honorable court, according to Baez, it was challenged, just like I challenged it on behalf of Mr. Williams, then how can this court sit here, the evidence that you heard, and say, well, there's a valid arrest warrant? We challenge that there's no valid arrest warrant, and then it's not saved later, in my opinion, the search, because I don't know how else law enforcement gets in the home. Because now, you know, thank God there's not a shootout in the house where law enforcement had to go there. On page 54, line 5, Your Honor, I continue. So I don't know how law enforcement, without a valid arrest warrant here today, has any evidence to go before the court. And that is why I made an issue of the other items in the search warrant, like the confidential source, the alleged confidential source, the murder of Mr. Thomas, because all of that doesn't save the search warrant. So that's why I thought it was important. The court states, the Honorable Judge Newkirk, on page 55, its ruling. On line 18, the court says as follows. All right, Mr. Steele, I'm going to go with you on this. I think you are correct. I think the burden is on the state to show the initial arrest warrant was valid and initial entry into the house was valid. And he hasn't done that, meaning the prosecutor has not done that. It appears there's no testimony from any officer. Certainly, there's no need for her to go back in the house without a search warrant. It doesn't sound like she searched for anything. So that might have been harmless, That might have been harmless error because the arresting officers discovered it and went out and told them. And this is what I'm stressing. Line 4, page 56, the Honorable Court's ruling. But I don't think we get to that hurdle because the lack of authority shown to the court that they had permission, meaning the police had permission to enter the house on the front side. So I will grant your motion, Mr. Steele, if you prepare a proposed order. I never did the proposed order. I don't know why I wouldn't do that when I'm told. Maybe I did and the judge didn't like it. That's not my order. The bottom line I'm trying to tell this honorable court with as much earnest and power and professional as I can is I do not want to relitigate this after I gave a roadmap to the prosecution on how to litigate. If they need me to help them litigate a case, I'm not helping them. The issue here is we had the hearing. I challenged the initial entry into Mr. Williams' home. He is the victim of constitutional rights that have been violated, and the state doesn't get to go back and do it again. Then Judge Newkirk's order. If you look at his order carefully, Your Honor, he does not just suppress marijuana. The prosecution, and they're great people, but on page 33 is all they want you to do, Your Honor. They want you to be in your foxhole and just focus with tunnel vision and say when the judge said all he's challenging is the marijuana and act like, well, that's all there was. The judge found that the entry was unlawful. We don't get to do it again. And Mr. Williams then tried for a year and a year to get back his property. And what did the police do? They tell him, it's the evidence. We're not giving it to you. The statute says it. And now today the state wants to come in and say, well, we had another search warrant. I will talk about that search warrant in a moment. Let me just show you, if you don't mind, the order of the Honorable Judge Newkirk, which I forget the number.
It is D4.
And Your Honor,
That's the first one.
thank you, sir. And it's entitled, it's filed, I know the hearing was on the 3rd of April.
And on the 11th day.
Right. So I'm speaking and all Williams' home, it says it's used defendant's home. After hearing testimony, a stipulation of testimony, an argument from the parties on Monday, April 3rd, 2017, this court hereby grants defendant's supplemental motion to suppress any and all evidence located from defendant's home. There is nothing clearer in the world of what was suppressed. The prosecution is intellectually not being straight. Based on this ruling, meaning everything's gone, the evidence located in Mr. Williams' home that is subject to this accusation. That's all. The accusation was just a marijuana case. Specifically, just over an ounce of marijuana is hereby suppressed and cannot be used in evidence by the prosecution in the trial of defendant Williams. Do you know where the judge got that language from? I know I didn't do this order because I would always say the honorable court. This is not the way I'd write an order. But you know where the court did get the language of what the state was relying, specifically just over an ounce of marijuana? It's in my motion. I said suppress everything, specifically including the marijuana. It is not true what they are telling this honorable court, and that's not acceptable. Then you go to the search warrant. The state wants to rely on a search warrant from 2016. It was signed by the Honorable Judge Woodson. It is signed and it's in your court's file. I believe it's defendant's number 10. I'm going to tell this honorable court. And it was signed on June 27, 2016.
I have the warrant for search and seizure as D10. You introduced that last time.
So, Your Honor, this is the same items that were taken from Mr. Williams' home in July of 2015. It's the same exact items that should have been returned. The state of Georgia has a search warrant. What they don't tell you, and I'm not saying they're hiding it, they just didn't tell you, is that they couldn't get into Mr. Williams' devices. They sent it to Cellbrite with the search warrant. And Cellbrite wrote back, and the GBI, we can't get in the devices. The search warrant then is never applied for again to tell any court like this court, by the way, there was a hearing and all the evidence was suppressed. The state is using then in May of 2017, after Judge Newkirk suppressed the evidence in April of 2017. The state then sends Mr. Williams' devices when they won't give it back to him. They won't restore it to Mr. Williams or his father, who had a power of attorney, they go to Cellbrite, and Cellbrite now has better.
Damn it, they muted again. When it was getting good, they muted us again. Oh. They won't let us know the technique, y'all. Put it back on. The sound's coming back on.
Open the items. They don't get another search warrant. The legislature then says at the last 3 lines of this code section, Your Honor, any search warrant not executed within 10 days from the time of issuance shall be void.
Oh, Mrs. Steele, sorry. Mr. Steele, go ahead, sir. Okay, go ahead, sir.
Seventeen 5-25, the last sentence that the legislature taught us. Any search warrant not executed within 10 days from the time of issuance shall be void and shall be returned to the court of the judicial officer issuing the same as, quote, not executed. The state doesn't have a search warrant in 2017 in May. They steal Mr. Williams' property. They illegally enter his home. They steal his property. Then they keep it, the stolen property. They keep his stolen, the property that they stole. And then they go to Cellbrite and they ask him in May of 2017, after everyone's on notice that the motion to suppress was granted, not even appeal. They didn't have the guts to appeal. And say,
Dang!
break into the devices. I mean, what are we doing here? And they want to do it again. I respectfully ask the court to enforce the collateral estoppel, res judicata, law of the case. It should have been restored. The police should not have had that evidence. It should have been given back to Mr. Williams. He shouldn't even have to ask for it. And I think that State versus Alford, I'm sure the court has read it, is telling the court something that the case does not discuss. It is just not even arguable that that case matters to this. They had additional reason to go into the home, into the car in Alford. They had the automobile exception. That is my argument when you asked me. I hope I answered your question. And I think, I'll answer any other question, but I hope I answered your question.
You did, sir. You did. Ms. Rosenwald?
Your Honor, I know Mr. Steele has an interpretation of the language of the order.
I think that his interpretation is right. I'm just going to tell you that. I mean, I look at the way it's capped, it's styled and everything else, and it makes sense with what you're asking me to do is kind of just narrowly kind of look at the marijuana and not anything else has been seized. He challenged everything that was taken at that particular point in time, and it's clear in the transcript that he did in fact assert the fruit of the poisonous tree. I mean,
So, Your Honor, if I may, when I looked at this case first and I saw his motion, I I was sort of thinking the same way as the court. And then I thought, I'm going to check the case law. I'm going to check what the actual order says. And when I looked at the order, that's when I started thinking it might be something different. And whether or not we interpret it a certain way, the language itself, the plain language, and I know that the directive from the appellate courts has been to look at the plain language of statutes, to look at the plain language of orders. The language itself says, the evidence located in defendant Williams' home that is subject to the above referenced accusation number, specifically the just over an ounce of marijuana. If the court had intended to suppress the remainder of the items after just stating, so the court says, the court grants defendant's supplemental motion to suppress any and all evidence located from defendant's home. He could have just said that, and that would have been a different ruling. But instead, the judge then said, based on this ruling, the evidence located in defendant Williams' home that is subject to the above referenced accusation number, specifically the just over an ounce of marijuana, is hereby suppressed. If the court wanted to make a ruling on the fruits of the poisonous tree, it could have, but it's clear from the transcript. And I'm not going to say Mr. Steele didn't argue about that during the hearing, but he didn't ask the court, hey, Judge Newkirk, can you please make a ruling on the fruit of the poisonous tree? There was no ruling on fruit of the poisonous tree. We're not talking about a second bite of the apple here. We're talking about him now challenging a search warrant that was not challenged before. And I think
Though, that's the thing about it. I mean, I think it's clear from reading the transcript and the exhibits 1 through 10 that were admitted when we were here on the 17th of November that he challenged everything: the arrest warrant, the search warrant, and he, in fact, he filed a supplemental motion to that extent. So Judge Newkirk granted the marijuana was only the subject matter of what you prosecuted for at that point in time. You had other things that were seized. Those things are fruit of the poisonous tree, or at a minimum should have been returned to Mr. Williams.
And so, Your Honor, I do want to pivot that if this court right now today says, hey, I'm wrong, and Your Honor finds that the cell phones are fruit of a poisonous tree, now and only now would Mr. Williams be able to demand his cell phones back. There has never been a ruling on the cell phones until this day, and I think that's really clear from the court's language in the transcript. Specifically in the transcript, the court says, and this is in the court's ruling, and Mr. Steele actually read it, it says we didn't get to that hurdle. So this is on page 55 through 56. The Judge Newkirk says it doesn't sound like she searched for anything. So that might have been harmless error because the arresting officers discovered it and went out and told them. But I don't think we get to that hurdle because of the lack of authority shown to the court that they had permission to enter the house on the front side. So I don't think we get to that hurdle. There is no ruling on fruit of the poisonous tree. There was no previous ruling on the cell phones. To the extent Mr. Steele wants to make an argument about the other search warrant in the other case, that other search warrant, we can do that today. We have the witnesses here. If this court can make a ruling whether that search warrant was proper. And we have testimony. We will explain the delay. We will explain that there was not the appropriate software available at the time of the warrant. We'll explain why all of that was lawful. But there's been no time to litigate that. The question now is whether there was a previous ruling on the fruits of the poisonous tree, and Your Honor, there just wasn't. And Your Honor, we have here the law enforcement, I do mention this briefly in my case, there was no finding that his rights were violated. There was a finding that the state did not meet its burden. Here, the officers acted in good faith. Again, we are prepared to show that there were proper warrants for everything. We haven't had that opportunity yet to show as to the 2016 cell phone warrant. We're ready to do that today. Now, Your Honor, there has just been absolutely no ruling as fruits of the poisonous tree. And if the court were to find
agency, when a final verdict and judgment is entered in finding a defendant guilty of the commission of a crime, any personal property used in evidence in the trial shall be returned to the rightful owner. All personal property in the custody of a law enforcement agency, including personal property used as evidence in a criminal trial, which is unclaimed after a period of 90 days following its seizure or following a final verdict and judgment in the case of property used as evidence, which is no longer needed in a criminal investigation or for evidentiary purposes in accordance with 17-5-55 or 56 shall be subject to disposition by a law enforcement agency. So this one is different than 17-5-30, which is pre-trial. So this is trial evidence, or what we do with evidence after the trial of the case. So that, and I mean, I still have an issue of that because you would have still had to return his property to him.
Your Honor, I'm sorry, I have to respectfully disagree with the court. Here, it's not a situation of what Mr. Steele challenged at the previous motion. It's what was ruled upon. There was no ruling upon the.
So if I had $200 and this situation happened, you wouldn't have to return the $200 to me if I won my motion to suppress?
Your Honor, if I had a search warrant that was valid, currently being executed for your $200, and it was for a separate investigation, a separate case, my position is that no, I would not have to return it until that separate investigation, that separate case was done, because I had a valid search. And obviously,
Do you have some case law that interprets 17-5-30 in terms specifically the possession of which is not otherwise unlawful? Because that to me says that would be any contraband, weapons, or things that you're not required to, not allowed to otherwise possess. But it doesn't distinguish on investigations or you holding on to evidence that otherwise should be returned.
Your Honor, I don't have a ruling a case at this time. I'm happy to provide that in a supplemental filing. But again, my understanding of the law is and has been that where there is, if a search warrant is currently being executed on a cell phone, for instance, the police are allowed to retain that property as part of an ongoing investigation.
But he won the motion to suppress.
Give me my $200 back.
But you took more than the marijuana. He wouldn't get the marijuana back anyways. He wouldn't get any cocaine that came back anyways. He wouldn't get a gun back if he's a convicted felon. But anything else that was proper, that was taken from that particular, house subject to the warrant, that's not otherwise illegal, is returned. The 17-5-30 says shall return and not be subject to further prosecution, because that's the whole thing about it is you don't get another bite at the apple based on this particular evidence. You can go ahead and do some, a separate investigation or whatever, but this evidence is supposed to be returned to the defendant.
Your Honor, our position remains that because there was a separate ongoing investigation for which a valid search warrant was in effect, and there was no ruling as to fruits of the poisonous tree, there was absolutely no reason to return that cell phone. I'm happy to provide the court with an additional brief, but that is our position at this time.
Okay. All right. I'm going to take 5 minutes, okay?
Thank you, Your Honor.
Okay. All right. We're going to be in recess for about 5 minutes. Okay.
5 minutes? No, return it.
Order the court, guys. Thank you.
Order in the court, order in the chat. Hold on a daggone minute, chat. The judge went to go get a pee-pee break. 5 minutes, he said.
Okay. I didn't see it.
The judge is getting ready to rule on it in a minute. He stepped away. The judge stepped away. What's wrong with their connection? Oh my God. The judge's pee-pee break is taking longer than 5 minutes. I need to stop putting my mask on my face again, y'all. I need to stop putting my mask on face because my sinus pressures came back. I think I'm gonna put my mask on. Hey, Jasmine. Alrighty, guys, we are here waiting on the judge to make his decision in regarding to them returning Mr. What's the name's properties, Mr. Williams' properties. That is just a young thug. Somebody. Hey, Vivian, we're watching the judge make his decision on this case. I mean, not the case, but the hearing, the ruling on the devices, like the phone and stuff like that. No, they talking about the device, the evidence. They're talking about the evidence. I didn't hear anything about no dismissal. Miss Perspective. I didn't hear anything about no dismissal. Only thing they talked about so far is the evidence. There, Oh, I heard you. All I heard saw the word dismiss. I ain't see anything else. So okay, I thought you were talking about dismissing the whole case. Oh, returning his item. That's what they're supposed to be, returning the evidence. Returning the evidence. They were supposed to return them. I didn't hear nothing about no dismissal. I heard returning evidence. It didn't say nothing about dismissal of anything. Returning the evidence. There ain't no mask over, nothing. Mask ain't got nothing to do with it. No, the weed ain't got nothing. Oh, Lord Jesus. They already said he's not going to get the weed back. They're talking about like his phone and stuff like that. Oh, my Lord. Oh, my Lord. The weed is not coming back, okay? Just like if it was contraband, like a gun, and he was a convicted felon, that's not coming back. The stuff that could come back is what's coming back. The weed is not coming back. They were supposed to return it because it wasn't supposed to be collected, hence the charge put on him. They want this evidence not to be used in his case and obtained illegally. Yeah. Okay, let me go see the charges against him. Hold on, I got the charges right here. We're gonna go over the charges against him. Hey, Mr. Wonderful, without evidence, there is no case, or no guns, no evidence, and gang activities from the phone. Oh, the phone, yeah. So then that the other dumb. Oh my God, look at the LOL. Oh my God, Siri, look at the LOL. What is look at the LOL? We got to see what they. No, they turned. No, it's not. It's not Georgia's video streaming system. It's them. The judge make an order. Okay, when I went in to do my application, right? You have to do an application for you to be able to bring, like electronic stuff in there, right? They tell you certain things you cannot play. So they have to follow the judge's rule. If the judge don't want them to play certain type of thing, then you can't play it. That's what it is, Gucci. It's not because it's cheap. It's because the judge don't want them to listen to certain things. Oh, hey, perspective. You can't tell jokes because your jokes come in like 5 minutes later, and I'm moved on to something else. So I don't know what the heck you be talking about. So that's why it's like, if you're not live up here, then you might be saying something that we talked about 5 minutes ago, and it's like, okay, what is you talking about? And it becomes dry. So my excuse on that. I'm sleepy. I'm about to go to sleep, but I gotta get outside. I gotta get outside in the cold. Should not put them in shackle, only save the shackle for violent white serial murderers. No, they let them out free. They give them bail. We got to stay out of their courtroom It's easy to get in, but hard to get out. But see, the thing is, they put fake charges on you too, Gucci. They put fake charges on you, and you can't get out. You look at, come on now. Let's not talk. Let's not. We gotta change it. We gotta. Let me stop. We gotta move to the cold spot so our skin could change lighter. Oh. Hmm. Because you could be right. You know, it's still dangerous to ride while you're black. You know that, right? While you have melanin. Melanin. Okay, Judge, you taking too long. You must have to take a dump. Judge is taking too long. He really. You think that officer right there, his shirt, do you think his neck, the back of his neck hurt? Because when he put his neck down, you see how he pushes the meat in the back of his head? Look at the meat in the back of his head. You see the meat? Do you think that hurt? Anybody got a neck like him that his shirt pushes down like that? Look at it. Yeah, it must hurt because he's touching his tie. Look at that. Look at his hair. His meat is being pushed up by his shirt. Look at it. You see that? Look when he move up. Look at the meat. Y'all see the meat? Try to make it louder. Yeah. And the other one scratching his head. I wonder if his shirt got a stiff collar. I wonder. That's why it's not good to be on TV and stuff, because folks be looking all kinds of stuff. I bet you he on the phone with that other judge clarifying and trying to find out ways to deny. I don't think so. The other judge is not. If that other judge rule on it, he ain't gonna help him to deny it. Nope. They'll be on their own. Oh, I'm sleepy now. I need to go to sleep. These people are boring me. I need to go out there and go to work. My sinuses. I do need to put my thing on because sinus pressure. Because yesterday it rained, right? And the altitude was pretty like gruesome out there. I bet on the phone with that other judge clarified. He's coming back. All rise. All rise. No, the judges don't look up case law. Their clerks do that. The people in their office look up that. You tell them, hey, look up this case. Give me some case law on this. Hey, Gamblers Anonymous. Hello. Happy holidays to you too. Hey, you got a ticket for me so I can win the $1 million lottery? Gamblers Anonymous slot scratch off. Who's that? It's not that many people in the courtroom. Look at it. It's only a little bit of people in the courtroom. Look at it. Most of the guys that are on cases in the courtroom. Look at them in the back. They got orange suit on and all that. Look at them. You said no, you don't have any. You got a $550 Christmas bonus last night at work, and someone just texted me and said, "Can I send them lunch?" Oh, go send them some lunch. Be nice. It's a give. It's a time of giving. Oh, she coming to introduce herself. Look at her. Look at her. She coming to introduce herself. She got to go to the bathroom. Look at everybody walking through there now. A Happy Meal. Backpack, backpack. Backpack, backpack. Here he come. He's coming back. See, he got his water. He got his pee thing done. He back now. Come on, y'all. Put the stuff back up. We want to hear it. Put it back up. Judge is an old man with an earring in his ear. There they come. Here come the sound. It's coming back now. Five, 4, 3, 2, 1. Okay, good people. We're still waiting for the judge to make his decision on the those evidence or properties, as they said, properties, defendants' properties, which were unlawfully received because there was no search warrant. They should have gave it back to them a long time ago. Long time ago. They had it over a year. They should have gave it back to them. Should have gave it right after the judge ruled on it. They were trying to get stuff open and all this kind of stuff. That's why it's hard to. What is he talking about? Go back to sleep. If you just running your mouth, I don't know what in the world you're talking about. That's why it's hard to get out. What is he talking about? What is Gucci talking about? They're making too much noise, y'all. No, it's not me that hit the wrong button. I was trying to turn it off because it's still making that noise. Hold on. Just hold on a second, y'all. We're gonna go in another route. We're gonna look at another station, see if they got the same noisy issue. They still not have it up yet, y'all. They still don't have it up. It says, we apologize as audio issue continue. The pool camera such supply the videos to all station is told that the sources of the problem. We unfortunately are not the station responsible for the pool camera. The court appointed that and have no direct ability to fix the problem and its source. We will do our best to communicate updates. Yeah, they still having problems, y'all. They're still having problems. Yeah, Boston ain't having the same issue. I just went to the attorney's channel. He's having the same issue. Sylvia, don't know if this is right time, but P&A was total awesome and needed it. What's P&A? Hey, Victor. Hey, Victor. We're waiting. They having difficulty with their equipment. They got this stupid noise making thing up. And we're not going to play that right now, that part of it. I was on the other station. The other station is having a problem. It's the feed that they have that's going into it. Whoever the court allowed to play this is the ones that we need to blame, right? We need to blame them. They're making us look bad, y'all. They're making us look bad. They're making us look bad. China 11 is still doing the problem, still have the problem going on. And so we have to wait. Let's see if they're back. Nope, they're not back. Okay, let's see. Let's see if it's working now. Let's see. No, they're not working yet. Nope. Still got feed issue. Think I'm lying? Okay, here it is. You think I'm lying? Here it is. I'm gonna show y'all. I'm not lying. See, they still got this stuff going on. Look at that. Same issue. Nothing. They still got that. But at least the noise is not going on right now. I just don't have any sound. All right, don't people under the bus. Let me see what y'all saying. Hey, Cynthia, make me think they're trying to hide something. I don't think they're hiding anything. If I was down at the courtroom, it wouldn't be able to hide anything. Because I'd be sitting right there in the courtroom. They're probably gonna end it for the day. They're gonna be there till 5. They don't close until 5. They're not closing until 5. And then last time I was over there in that same courtroom, they stayed there forever until they closed the last case that's supposed to be on the calendar. They don't care. All the hearings are gonna be heard. And sometimes they have to stay to 6 o'clock. Prayer and affirmation. Oh, you guys and your acronyms and your abbreviation. I'm not into abbreviations like that. Janice, you funny. I'm like, what's P&A? Oh, thank you for putting me onto it. P&A is prayer and affirmation. Thank you. Okay, yeah. I look like I'm about to go sleep. Yeah, this is boring me. I'm sleepy. I am sleepy. I've been sitting here. Let me go turn on my app so I can go to work. I was trying to get this stuff out with you guys, but I got to go to work because we're not. Let's see. There's nothing going on in here. See, it's not moving, not doing anything. Hold on a second. Sinuses. There's a flood warning today? Oh, wow. Guys, I was trying to wait till this stuff is over with, but it seemed like they're not moving. It's not moving, good people. Thank you for all my new subscribers. Thank you for being here with me. I appreciate y'all. Just from watching this, I got 18 new subscribers, y'all. 18. Sean says, hey, Sylvia, they treat blacks so wrong. This judge is trying to find a way to deny the motion. Y'all, stop thinking negative. Okay, they're back. They're back, y'all. He's smiling. Look at it. His attorney, that guy's smiling, y'all. Look at him. He's smiling. He's smiling. If that guy's smiling over there, something went wrong with the lady. The guy's smiling. Okay, the noise.
Yeah, it's all. Yes.
Your Honor, what the state would like to put in as the warrant for search and seizure, an affidavit for search warrant. These are already D10.
Yeah, they're in D10, madam.
Yes, we have two more.
The arrest warrant out of DeKalb County that I challenged. The state would like to introduce this. That's already attached and in with the state's motion for reconsideration. I can't remember what number it is right now.
Your Honor, we just asked if we could just admit it as a separate exhibit to this hearing. It's certified. It's self-authenticating.
Well, it's already in evidence. And the last one is already in.
Well, any objection to that one, the search warrant, arrest warrant, I should say, Mr. Steele.
I will lodge an objection at this point. Yes, sir.
Basis?
Basis is that it is attempting to relitigate something that should have been done before. It has no bearing on this motion whatsoever.
Your Honor, we would like a complete record, and if it's already, as Mr. Steele says in the record, we don't see the harm in simply perfecting the record with a self-authenticating document.
Well, the issue is you didn't introduce it at the hearing in 2017. That was the basis for the ruling for Judge Newkirk. So I don't see why I would need to accept it right now. I mean, because I'm going to rely upon Judge Newkirk's ruling.
We just like to have it in the record, so we may use it just to complete the record, Your Honor, not for the purposes of argument in this particular instance. Should the court wish to rule with us and have a hearing on this, then we'd enter it separately, but for the purpose of the record, we'd seek to introduce it right now.
Let me see it, please.
Yes, Your Honor. It's certified.
The judge seems like he's frustrated, y'all. He said you should have put that in back in 2017, not now. Look how frustrated she looked.
All right, Mr. Steele, I'm going to admit over your objection, okay? It states one for purpose of the motion.
And Your Honor, then we'd also just move to admit a certified copy of the search warrant to evidence home. This was record. It's a certified copy.
They just want to perfect the record,
Objection
y'all.
is attached as Court's Exhibit Number 2,
They want to
pages
perfect the record.
57.
How you gonna perfect the record after the
58.
fact?
All right,
No, it's already, the court admitted that as an exhibit earlier today.
Oh, the transfer was admitted, Your Honor, but we'd like to admit the certified.
okay, all right, certified copy, states 2 for purpose of the motion?
Yes, Your Honor.
Okay, all right,
As Mr. Steele stated, the other was D10.
yeah, I've got, that's admitted already.
Is that
So,
certified, Mr. Steele? No.
but it was admitted in the hearing on the 17th of November.
May we also tender this as a certified copy of that search warrant, though? As states 3.
All right, any objection? Or same objection, sir?
Yes, sir.
Okay, all right, states 3 is admitted for purposes of the motion.
Thank you, Your Honor.
The judge seemed like he's frustrated.
Anything else?
Anything else?
Anything else in terms of the states and states 1, 2, or 3 for purpose of motion?
Well, Your Honor, we would ask to have a hearing to have the opportunity to show that lawful entry to the house and the search.
Now she wants a dang on hearing.
Going to allow us to do that, but if we are, we're ready to do that, we'd like to do that.
I'm not inclined to have a hearing on this, okay? Because, and here's why. The Judge Newkirk's ruling fairly contains some principles of criminal procedure. And even though you've admitted these particular items for purposes of the record, which would supplant bias and would make the issue of that's one argument you could make in terms of the sufficiency of the arrest warrant and the search warrant. The issue still becomes is that that issue was decided by Judge Newkirk earlier, and you all from the state have not given me any. You're still not getting over 17-5-30. There still would be no reason for you not to have returned this property. There's nothing in law that would indicate to the court that you had the right to, you know, to maintain and continue to investigate on those particular items that were taken. But so that's why I don't need to have a hearing necessarily on it, on that particular issue. So with that,
Your Honor, with the court permit,
oh my God, lady, get the man back his
we would
stuff.
like to proffer what the evidence would show, where we permitted to introduce the witnesses that we have. As the court,
I'm okay with that. I'm okay with you all. Well, I mean, the warrants would supplant the certified copies of the warrants that you have at this point in time would supplant Mr. Steele's argument. But still the problem that you're going to have is that 17-5-30 would have required you to still return that particular property. There's no case law which indicates that particular issue, and the statute is pretty clear. It says, you know, motion, if the motion is granted, because Judge Newkirk granted that motion, and it shall not be admissible against evidence of movement in any trial. So basically, you know, you're getting a second bite at the apple. And in that particular circumstance, that's why the legislature makes some very specific issues about 17-5-25, which is execution warrants, 17-5-30, which is motions to suppress, and then 17-5-54, which is different. That's trial disposition of property. So in that respect, that's why in this particular circumstance, you all still, now, if you've got another argument as to why you didn't, other than why you didn't return his property, but you would have still needed to return it. I mean, you didn't go forward with that prosecution. If you've got some other case law you want me to look at, but it's pretty clear. The reason that the legislature did enact this statute is because they didn't want the state.
Give him back his property. Oh my God, this audio again, y'all. Come on now.
Yeah, and Mr. Steele's argument is, and just hear me out, you didn't have a valid arrest warrant to begin with. Now you got one, but you didn't have one when you had one in front of Judge Newkirk. You sought a search warrant, so you weren't in the right place and space to begin with, because you went in the house, somebody saw some marijuana, or somebody saw whatever it is, and they, in D10, they got they drew an affidavit, and they said, okay, we want to search the house. Well, you got to be in the right place and space to begin with to have the authority to search the house to begin with. Mr. Steele and his motions asked for suppression of anything that was taken in the house. So marijuana and anything else that was the basis of that. So that's fruit of the poisonous tree. He's argued that all throughout his motion. He's argued that. And so Judge Newkirk, by implication, had to consider it as part of his ruling. So you asking me to kind of, okay, well, the marijuana is over here, that's fine, but he didn't suppress the other stuff. We can still use it. That's not the way I interpret this particular scenario and interpret the law related to search and seizure of this particular item.
Your Honor, thank you, and respectfully.
Oh my God!
The issue of whether or not the state had a valid arrest warrant is
Oh my
actually
God, they're getting on my nerves.
proven
Look at the
with
perm.
respect to, did we have one with the certified document that the court has, that the state has tendered as evidence? So it's not a matter that the state did not have lawful authority to enter into the home.
But you didn't have it at the time that Mr. Steele.
We had the search warrant. That search warrant, that certified document that is in evidence, Your Honor, has a date on it. It was signed and filed well before Mr. Steele made that motion, and it was a part of the record of the clerk of court in the.
But you all didn't,
It was sworn out in.
the challenge is you all didn't take that up on appeal or anything. It was ruled upon by Judge Newkirk.
Your Honor,
So at this point in time,
God.
is it fair to Mr. Williams for you to have another bite at the apple? I mean, at this point, because you're asking me to go ahead and let you use this particular evidence that arguably another one of my judicial colleagues has said, hey, despite the fact that we disagree about how the motion has been styled, clearly it would be subject to being suppressed.
and Your Honor,
And even if I agree with you, okay, let's say you corrected all that. 17,530 is still fatal to you. You still would have needed to return the property, and you haven't given me any legal justification for you to keep that property and continue to then investigate that property or search that property. Unlike trial evidence that clear you could have done that. 17,530 is distinguishable because it's like the legislature seemed to indicate, well, we don't want the state to go ahead and continue to keep investigating an individual based on evidence that a court has suppressed. So
Your Honor,
that's kind of where I am.
Your Honor, if I may,
No.
the distinction is that there was a good faith basis
Oh my God.
for obtaining the search warrant and for getting the search warrant. A search warrant affidavit for the home itself was sworn out. There was, in fact, an arrest warrant that did exist. It was lawful. The fact that there was not one presented in the 16 SC case is what,
He said
yes,
no.
caused
Go
Judge
down.
Newkirk
What's your
to
term? Go
suppress
ahead, term.
the evidence as to that case, Your Honor.
Okay, and why didn't you return the other stuff to Mr. Williams? You wouldn't have had to return the contraband. Everybody's clear about that. Contraband or weapons would not have been returnable to Mr. Williams. Why didn't you return the other stuff?
We had actually sought the search warrant, Your Honor, and I think that the court can look at the dates on the search warrant, on the arrest warrants, and see that we had actually
He's not
already
answering the question, y'all. He's
received
not answering the
from,
question.
we had received lawful authority to search. We had already sought and obtained a search warrant for the items. We had already
They
obtained
hard
what
about
the
this,
state
y'all. That means
believed
that whole
was lawful
case is under that
authority.
stuff.
If Judge Newkirk has already suppressed the marijuana under the same analysis, okay, then why wouldn't the rest of the stuff that you took be suppressible at that point in time and fruit of the poisonous tree?
Your Honor, the ruling by Judge Newkirk came after the state sought permission to search the items. So we had what we believed to be lawful authority to search the items, the search warrants that were obtained, and we have witnesses
Okay,
that will testify.
assume I believe you, okay? Assume I believe you.
Yes, Your Honor.
All right. Still, Judge Newkirk grants the motion to suppress. The case is over. You can't proceed on the 16 SC case anymore. The evidence that you all took, why didn't you return it?
Because, Your Honor, at that point, we have, from sources, we have probable cause to believe that within items located within Mr. Williams' home, and this is separate and apart from the fact that he possessed marijuana, but at this point, we have information independent of that to believe that within his home, we would find evidence of these other crimes that we were at that point investigating. Prior to Judge Newkirk hearing the motions, prior to Judge Newkirk issuing the order that he issued, even
that her case is over.
even if the court were to see it as more expansive than the state believes that it is, we had probable cause based on information and sources independent of the fact that the defendant had marijuana or firearms or whatever it was that was seen when the officers initially entered the home to execute what was and what is. It doesn't change it. The fact that the arrest warrant that was in existence at the time actually was valid and gave them lawful authority to enter the home does not.
Judge Newkirk ruled that you didn't have that at that point in time, because at the hearing that you had in front of him, or Mr. Bailey represented you all on the 3rd of April of 2017, that was, you didn't have that particular certified copy of the arrest warrant. And so Mr. Steele, by argument, says, hey, look, I am extending my motion. I'm going to include everything that's in the house because you weren't validly in the correct space and place. Now, had you had that search warrant at that point in time, or not search warrant, but the arrest warrant valid at that point in time, then Judge Newkirk would have probably said, okay, well, then you're fine. But that wasn't that, these particular scenarios have to be ruled upon in terms of what the judge has at that point in time. So if you look at that, even if I accept, which I have, I've admitted, states 1, 2, and 3, you still have to return the man's property. He's asked for it to be returned. He hasn't had it returned pursuant to 17-5-30, because I can't go back and unring the bell in terms of Judge Newkirk's. You're not saying Judge Newkirk's ruling was erroneous, are you?
I'm saying that Judge Newkirk's finding was that we had not presented a certified copy of the arrest warrant, which is not the same as that there was an unlawful search and seizure. It's just that the state had not tendered.
On 3 April 2017, that's exactly what he was doing. Okay, so you're asking me at this point in time to say, hey, Judge, we can correct that. On December the 15th of 2022, you've introduced states 1, 2, and 3 certified copies of the arrest warrant, return of search warrant and inventory, and the affidavit for search warrant. And that's why I'm telling you, assuming that that is now corrected, the problem that you still would have is the return of property under 17-5-30, because you took the marijuana and the other pieces of evidence from Mr. Williams' home. I don't think the law distinguishes between that. So you would have had to return that. You still would have to return the property to him. So because at this point in time, he's entitled, or he would have been entitled, he's asked, and Mr. Steele has already introduced from in the last hearing on the 17th, he's asked me, or he's introduced a letter that he sent to Mr. Bailey saying, hey, I want the evidence back.
Your Honor, but the court did not rule that the state had to return that evidence, number one. There was no ruling as to that.
I disagree with you. I disagree. By implication, Judge Newkirk had to have considered the fruit of the poisonous tree. Mr. Steele asked him to do that. And it's a snapshot in time. So on the 3rd of April, 2017, you didn't have what you have now. And so you're asking me to correct something that is arguably, can I do that? I mean, and even if I can, that still runs afoul of 17-5-30. You still would have had to return Mr. Williams' property. And then Mr. Steele asked you for the return of that property. And there's no exception under 17-5-30 pretrial that gives you the ability to keep the property. You have to return the property. The property and then you took that particular property, in particular his phone, and then you extricated things out of it, which would be tainted or fruit of the poisonous tree, because you didn't have the right to keep that. You didn't have the right to keep that particular evidence under 17-5-30.
Thank you, Your Honor.
Finally, Lord Jesus. Okay, can we get the stuff back?
All right, let me finish what I was what I was gonna say, okay? For purposes of Mr. Steele, you can prepare an order, okay? Sufficient, to recap what the court has indicated, during this particular, motion. Now, I know that puts us in a position where, some stuff that you may have, the state was gonna admit or utilize. Does that change your position, ladies and sir, about where you are with, what would be admissible, in this particular prosecution?
Your Honor, there are items, that of course, are affected by the courts, suppressing the evidence, that was seized back in 2015. There are some items that we believe, may have more evidentiary value than others. And so it does affect, the evidence that the state intended to introduce in this case.
Well, I was just asking because if you need to sit and talk with Mr. Steele about what you can agree that would be, not admissible at this point in time, given my ruling.
Oh my God, them and their stupid audio. Oh my God. We can't even hear the judge, y'all. They're doing it again to all of us. Come on. We want to hear what the judge got to say. Oh my Lord, y'all. We missing everything. We missing everything. We missing it all. We missing what the judge is saying. Oh my goodness. Oh my goodness. And we're missing it. The judge is speaking and these people have their audio messed up. Oh my Lord. They messing us up, y'all. They messing us up. They are messing us up. They need to fix this stuff. Janice is because they probably was going to use it against him, like the phone records and all that. They have to return his phone and all that. Why are they doing this to us? They really messing us out. We can't even hear. We can't hear nothing. Can't hear nothing, y'all. They're really messing us up with our hearing thing. You can't just nobody. You can't even. There's no capture because you can't hear it. The thing won't be able to hear them to do the capture. There's said put on a capture? It is on. Oh my God, we don't hear them. Okay, it's coming on now. Hold on.
At the trial, those records were obtained through an order from Superior Court at the request of the former district attorney. They contended that the seizure of their records without probable cause was a violation of their Fourth Amendment rights and that the records should have been suppressed. The court in Kessler found that like bank records, telephone, toll, and building records are not owned or possessed by the defendant, but are business records belonging to the telephone company. The court further stated that the cases cited by the defendant, United States versus Baxter, Katz versus the United States, recognize the right.
There they go again, y'all. Damn it, they stupid.
Right of privacy in the toll and billing records of the telephone company. The court went on to say that neither defendant, as one user of the telephone, nor the other defendant, as its lessee, had standing to object to the production of these records by the telephone company. Further, Your Honor, Regis, R-E-G-I-S-T-E.
One more time, R-E-G what?
I-S-T-E.
Okay.
Versus the state. And that is 292, Georgia 154. It's a 2012 case that is directly on point with what we have at hand. As an initial matter, telephone billing records are business records owned by the telephone company, not the defendant. As a result, defendants generally lack standing to challenge the release of such records under the Fourth Amendment because they do not have a reasonable expectation of privacy in records belonging to someone else. And that's a pen site of 249 Georgia 462 at 469. Accordingly, the court held that the appellant was not entitled to challenge the release of phone records in this case on Fourth Amendment grounds. Your Honor, the issue of standing has to be addressed before the court begins to even look at any substantive matters in this case. And given that the defendant has no reasonable expectation of privacy in the cell phone records of the Hertz Corporation, he has no grounds, no standing. He has nothing that permits him to come in and argue that the court should somehow find that the state's method of obtaining those documents was somehow improper. Additionally, Your Honor, the documents were turned over to the state by the Hertz Corporation. If the Hertz Corporation wanted to contest the release of its own documents, the Hertz Corporation and only the Hertz Corporation, and all that they released, I will also make clear, it's not at all anything comparable to information contained in cell site location data that a person has within a cell phone that is kept on their person and that moves around with them. These documents are simply documents that show that the defendant rented from Hertz a particular vehicle at a particular time and returned said vehicle at a particular time. There's no location information data to which the defendant could in any reasonable way have a reasonable expectation of privacy. Additionally, Your Honor, again, the records do not belong to him. He has no standing, no expectation of privacy in them, and he is not properly before the court contesting or moving that the court suppress the release of Hertz's own records to the state. So again, as well, Your Honor, the law on standing requires that the defendant show that he has standing, and his claiming that, just baldly claiming that the information sought somehow references or, as he put it, it touched upon the defendant or information concerning the defendant, still does not give him any standing to argue or ask that the court suppress information lawfully turned over that he has no expectation of privacy in, even if it was unlawfully turned over. He cannot argue that the court should suppress these documents. He does not have standing to move the court to suppress the documents. There is no infraction of any law or code of conduct. There is no incursion on any protected rights held by the defendant. He is.
Yeah, it looks like from Kessler that he has a reasonable expectation of privacy in a conversation. He doesn't have the reasonable expectation of privacy in records. And so is that kind of sum and substance what your argument is, madam?
Yes, as an initial matter, yes. And I mean, I ask the court rule on his lack of standing before we do anything else related to it. Thank you, Judge.
Okay. All right, Mr. Steele, what say you about standing? It looks like that these are the Hertz records, correct?
Yeah, they're included, that's true.
Okay, is that what you are, as an initial matter, I would agree with Ms. Lovely, your client does have to have standing. I would agree. I would also tell you that conversations are different than records. So tell me why you think that he has standing to contest these records.
Okay. Well, and when the Honorable Court started to get into this motion, the court actually asked about Mr. Williams' motion to dismiss the indictment and or a motion to suppress evidence and derivative evidence based upon prosecutorial misconduct and abuse of grand jury powers. That was filed on November 3rd, 2022. I supplemented that, Your Honor, on November 10th, 2022. It's the same title, but I wrote supplement to Mr. Williams' motion to dismiss the indictment and or a motion to suppress. It also goes hand in hand, if you don't mind ruling at one time, I believe it goes hand in hand with the Mr. Williams' motion to suppress number 3.
Well, I need to deal with the issue of the phone records. That's what you asked me to do.
The Hertz records.
The Hertz records. So let's deal with the Hertz records first. There may be other issues as to the indictment and some other things. But let's deal with that first. Client's got to have standing in order to address that particular issue.
So I raised it twofold. I raised the motion to dismiss the indictment based on prosecutorial misconduct. Records of another company, although we want to assert standing, Maddox and the DDOS versus state says that there is no standing in those records. So I will, under the current case law, I'm not waiving the issue, but I'm telling the court like I'm obligated to do of the case law, and Maddox is.
I would agree. You disagree because you represent Mr. Is that Have I correctly, summarized that, sir?
Well, it's not like, because I represent this, I think the law is inaccurate, but the way I understand the law today, we have to follow MADDOX versus state 346 Court of Appeal, 674, 2018. It's exactly correct what, Ms. Love said, that there's no standing records of a corporation when you rent a car. But that really wasn't my issue. That's why I supplemented it. And that's why I did the separate motion to dismiss the indictment. And
Judge,
the reason,
if I may, and I do apologize to Mr. Steele, but I hear him going into the substance of a thing that necessarily relies upon his right to complain about the state's method of obtaining the records from hers. So I would ask that.
Let me deal as a preliminary matter, threshold matter. If that's the case, the records, your client would not have standing. I would grant the state's motion as to that, as to the cursed records.
understood.
Okay, so is there any other basis that you are asking for at this point in time?
Yes.
Okay, all right, what's that?
Okay. So, and the reason I want to call Mr. Sprinkle, if you allow me to briefly proffer. I just
Okay,
want-
you're gonna proffer as to why you need to call Mr. Sprinkle.
Yes, because I think that's where it starts. So what happened is, Your Honor, is Mr. Williams is wrongly targeted by law enforcement for 10 years, since he's 21 years of age. And during those 10-year period, there's a systematic abuse of process by the people who claim that other people break the rules, and that's the District Attorney's Office of Fulton County. And what I'd like to call Mr. Sprinkle and prove to this honorable court is as follows. First is what you just heard from. Law enforcement officers and the District Attorney's Office is aware that the Honorable Judge Newkirk found that law enforcement had no right to go into Mr. Williams' home in July 15, 2015, take devices. The prosecution does not restore those devices. You already ruled, I know Judge Newkirk ruled, but that's part of the issues. What right does the prosecution, the District Attorney's Office, have to keep that property and then to send it to Cellbrite without a warrant and have it searched? I want the court to consider that. Then I want the court to consider the following. The fact that the District Attorney's Office did not go back to a judge and say, we have this property, we're supposed to give it back. We are doing another investigation, we want another search warrant. They just go and Cellbrite, I would introduce through Mr. Sprinkle, says, as a courtesy of the District Attorney's Office, we're going to look at this device. I would like the court to have that in its breast when deciding whether there's extreme prosecutorial misconduct. Then what happens is grand jury subpoenas. I'm not moving to suppress anything at this point. I'm not waiving any argument, but I'm not moving to suppress. But this is how the grand jury subpoenas were given out in this case. And it's not only hers. It is every grand jury subpoena. I've attached them to the motion. And what the grand jury subpoena shows is that from his office, presumably, Mr. Sprinkle is on every one of these. He has a district attorney seal on the subpoena. The law requires the clerk to seal a grand jury subpoena. Mr. Sprinkle sends all of these subpoenas outside the state of Georgia. There's no authority for
that Mr.
a
Steele indicate which subpoenas he is referring to when he says all, because the only one that I'm aware of that he has referenced is the Hertz subpoena to Florida. But as a matter of fact, I would just let him continue and I will not.
Yeah, he's proffering as to why.
Oh, he is actually.
Why?
He is.
She keep cutting him off, y'all. This is ridiculous. Here we go with the daggone sound again, y'all. Why they tapping the sound? They keep messing with the sound. Here it comes. It's coming back. It's coming back.
Subpoenas that he is complaining to the court about.
Okay, so Ms. Love's argument is, and the court's inquiry review is, what reasonable expectation of privacy do you have, or standing do you have in these records?
This is not the issue. This issue goes to dismissal of an indictment for prosecutorial misconduct. Mr. Williams was indicted. I'm not trying to suppress the evidence based upon your ruling and the case law. What happens now is there was such egregious misconduct by the district attorney's office.
So you're saying you'd like to examine Mr. Sprinkle for his motives, or for as to why he sought these particular documents in his prosecution.
I want to subpoena, well, I have subpoena. I want to call Deputy District Attorney Mr. Sprinkle, because I want to ask him why he believes he had any right, which I'm contending violates Mr. Williams' rights to due process as stated in State versus Lampel, LAMPL, 296 Georgia, 829. It's in Division 2, 2015 case. It's in my motion entitled Mr. Williams' motion to dismiss indictment and or motion to suppress evidence filed on 11/3/2022. And what the Supreme Court of Georgia held was it is an extreme remedy to dismiss an indictment or account thereof. However, it is a remedy. It's a due process violation. When the state's talking about standing, you can't have more standing than all of these people here who are indicted, wrongly indicted based upon the misconduct of the district attorney's office. And we don't have to sit here and allow the district attorney's office to violate the law and just put us in an indictment without this honorable court hearing it.
Right.
And if this honorable court finds that it reaches the level of outrageous prosecutorial misconduct by the systematic abuse of process by our district attorney's office, then the indictment is dismissed. The state is arguing something that has nothing to do with this motion. This motion is not a motion to suppress. It is a motion based upon a violation of due process rights, because everyone here, I assume, joined the motion. Everyone here is suffering from the state of Georgia's unlawful abuse of their power.
What's
That's the
Lampel's
issue.
site again?
Mr. Lampel's site is .296 Georgia, 892 Division 2, 770 Southeast 2D.
Tell him.
629, 2015. I had the honor of representing Mr. Lampel on that case. It went to Court of Appeals of Georgia. Then the state sought certiorari, and that's how the Supreme Court got that case. He's the mayor of Mara. Mr. Lampel's the mayor of Mara.
Okay.
And that's why I would like to call Mr. Sprinkle, because he's sending out under the auspices of a grand jury subpoena with the district attorney seal, without the clerk seal, outside our state. They've taken evidence from Mr. Williams' home, not returning it, searching it, regardless of Judge Newkirk's finding. And then, Your Honor, what I'd like you to consider, and Mr. Sprinkle would be asked, there's a recording in a grand jury, and it happens on June 15, 2018. Mr. Sprinkle and law enforcement officers who were present in this courtroom subpoenaed a woman named Ms. Morton, Morton. They brought her before the grand jury in Fulton County. They didn't like that she wasn't talking with them. They put her under oath. And they said, it's Mr. Sprinkle is said on recording right at the beginning. It's at 10 seconds of the recording. He says, because in Georgia, it's not an investigative grand jury unless the court deems a special purpose grand jury. It's not federal court where you could do an investigation. The state of Georgia, you need a proposed bill of indictment already against the person and what the charges are. State of Georgia versus Brian Steele, here are the charges. What Mr. Sprinkle tells the grand jury is, this is not an indictment under consideration. We are just here to hear Ms. Morton testify. That's not valid. So I'd like to ask Mr. Sprinkle what right he had to use the grand jury as a district attorney's investigative tool. Those are my five issues. The search warrant, the search of the devices, which we already ruled. Why did that happen? Why did the subpoenas come without a clerk? Third one is, why would the subpoenas go outside of the state of Georgia? The fourth one is, why wouldn't you return the property? And the fifth one is, why would you bring a human being before a grand jury when you don't have a real bill of indictment, and you tell the grand jury that this is not a bill of indictment under consideration? What right does the district attorney have? And that's why I subpoenaed the young man.
Your Honor, the defendant still has not addressed the issue of standing as any of the.
He's indicted.
No, Your Honor. The conduct that he is complaining of, he has to have been agreed. He has to have an expectation as it relates to that conduct.
I think that's what he's asking me to test. I think that's what he's asking me to test. And he's also saying, hey, he's an aggrieved person because he's under indictment for these bigger charges. So,
and Your Honor, if I may, I don't know why Mr. Steele cited Lample in his brief, because it actually supports the state's position in this case. In Lample, a special purpose grand jury investigated the defendant and subpoenaed that defendant. In this case, it isn't even that the defendant was subpoenaed to testify. He is talking about a person who didn't even yield information that was used against him. He is asserting that actions that he has no right to complain of should be somehow used as a basis for dismissing a lawful indictment against this defendant. So he is, I guess, attempting to leverage the court's ruling previously into something that simply doesn't exist. He does not have a right to complain of the actions he asserts were unlawful or improper. He simply doesn't. And he hasn't addressed his being indicted alone does not give him standing to argue or to complain about the fact that Ms. Morton was taken before a grand jury, or that a subpoena was sent to a corporation or a company or an entity that the defendant has no expectation of privacy. He simply doesn't get past that initial threshold. And by continuing to fold one argument into the other, he attempts to subvert what the court's Supreme Court. They've been indicted. And when the Georgia Supreme Court says, nope, you lack standing, it being indicted doesn't afford them standing to argue about matters that they have no right to complain about. And so he has bundled up a whole bunch of matters as they relate to other entities. Frankly, with respect to Hertz or any other entity, they could simply give us the documents we requested them. They could literally email them to us, as some of them will do. But the only entity and the only people that have a right to complain about that, and right now he's skipping over the fact that he has no right. He's asking you to jump right to, let's just get into the substance of the argument. And that is not the way that the law works. Mr. Steele is well aware of that. He is a very seasoned attorney. And he is attempting to escape that fact by just pushing forward and conflating all the arguments and making sure that they collapse into one mud pie. But Your Honor, I believe, and I'd ask that the court address that threshold matter before we get into anything else. And specifically, before we begin bringing assistant district attorneys in to talk about what could constitute work product and to discuss matters that have nothing to do, that are in no way matters that the defendant has a right to complain about.
All right, well, just give me a second, please.
I'm on mute and I'm just listening. I'm not doing anything, but I have to listen to this. Sam's got a project and it had to be printed on a poster. The poster printing printer at FedEx is broken, so is the one at Office Max.
Gucci, women don't piss. Women pee pee.
Mr. Bailey's, not Mr. Bailey, but Mr. Sprinkle, you're challenging by way of the evidence that you were presenting, or that I said you didn't have any standing to see what Mr. Sprinkle in fact did present to that grand jury and what he told them. So
I actually won't do that. What I'd like to do is, why did Mr. Sprinkle serve grand jury subpoenas? Why did he do the process the way he did? I'm not going to ask anything about what happened in grand jury, except I have that recording that was given to us in discovery.
Was it discovery?
Yes. Okay. Will not ask anything about what occurred in grand jury, except what was given to Mr. Williams in discovery by the state of Georgia. It's a recording.
Wes, do we have a copy of the motion to suppress? Yeah, that's what the motion was. Okay, I moved upon the issue of the all right, I think I'm back on at this point in time. In terms of the motion to quash the business records, I'm also going to grant the motion to quash the subpoenas, both subpoenas 1 and 2. The court is of the opinion that of the relevancy of these particular records, but also they're protected by work product under 24-5-501. And for those reasons, I'm going to I'm going to grant the state's motion to quash on those two subpoenas. All Anything else?
Thank you, Your Honor.
All right. I have some proffers I need to deal with. Let's see, Mr. Where is he? Mr. Hoover?
I'm sorry, Your Honor, before we do that, I just want to bring the court's attention. Mr. Kendrick has voted to suppress statements on the record. We have a witness here, a spoken to counsel. He doesn't intend to go forward on that motion.
He does not intend?
We were hoping we could release our witness. Who's going to answer that?
Yes, any objection, counsels?
No, just to be clear, we're not withdrawing the motion. We would just like to argue that on another time.
And your name again, I'm sorry.
Doug Weinstein, W-E-I-N-S-T-E-I-N.
Mr. Weinstein, what's your client's name again?
Yolanda Kendrick.
I'm sorry, Your Honor, we're just hoping our witness might be able to go.
Well, you know, folks, I'd like to be able to accommodate everybody, but you saw what happened this morning, okay? We had a technology glitch that nobody could have foreseen, I should say, and we're kind of a little bit behind. So we're a little bit behind in terms of just being able to properly conduct court. So, what is your motion? Your motion is to suppress?
Yes, Your Honor.
Could you give me just a few minutes and I can maybe have that motion heard since your witness is here?
No, Your Honor, I believe he doesn't want it heard today, and we don't object to a continuance. So
Oh, okay, all right, so your motion is suppressed, all right, we're gonna, okay, all right, I understand,
Thank you, Your Honor.
I'm with you, okay, yes.
Your Honor.
You give a mouse a cookie, what is it you want, Mr. Sharp?
Thank you, Your Honor. I just wanted to make sure that I respect the record. I know that you have not ruled on the
It's not your
motion.
turn yet.
Well,
You
I
jumping
have-
in front of Mr. Steele now?
no, I am not jumping
Okay,
in front
okay,
of
okay, all right, what is it you'd like to tell him?
Well, I filed the exact same motion that Mr. Steele filed
And
regarding
your client is, sir,
Stillwell.
Mr. Stillwell,
And that
okay.
was filed on November 16th. And
The motion to dismiss the indictment
motion to dismiss the indictment.
and motion to suppress evidence, you wish to table yours at this point in time?
I have not heard you rule on the actual motion, just on the subpoenas. And I would just point out to Your Honor that our argument is not based on any Fourth Amendment violation that would require standing, but rather prosecutorial misconduct, which I believe as citizens of the United States, we all have standing to challenge. And Mr. Stillwell, who has been indicted and investigated in part by illegally issued subpoenas.
I'm gonna deny the motion to dismiss the indictment, okay?
Okay, well, I just wanted to make sure it was on the record that I too have filed that motion and.
All right, I'm with you. Okay, all right. So to the extent that's been ruled upon, that's fine. Anything else?
Actually, Judge, just while we're here for the record,
Yes, Mr. Meneses.
I have failed to adopt the motion as writing, but I did want to respect the record that that's on me, and that was effective, but I do want to orally also adopt Mr. Steele and Mr. Sharp's motion. Just for that misconduct.
All right. Well, you probably should reduce that to writing, but Ms. Rosenwasser, if you will include that in order, please, madam.
Yes, Your Honor.
Yeah, I'm going to, in the motion to suppress and motion to quash, okay?
And Your Honor,
You can-
would you allow me to incorporate Mr. Steele's argument into the record on behalf of Mr. Steele as well, so I do not need to cite to the city cases and,
Yes,
thank you.
so we'll include you as well. Okay, anybody else? All right. Okay, before I was interrupted by Mr. Sharp, Mr. Hoover.
Yes, Your Honor.
Okay, do you have the issue of the proffer that you'd like to complete at this point in time? I was gonna ask you to complete that issue of the proffer. And then also, if there's anybody else who we still need to deal with the issue of the proffer.
I'm not sure which proffer.
Ms. Rosenwasser, you want to address that, please?
Your Honor, I believe the court is referring to your continued, Mr. Hoover's continued representation of Mr. Someone. after, you were disqualified as to Mr. Blaylock, to see if Mr. Blaylock was on board with you continuing to represent Mr. Selma.
Well, Mr. Blaylock's attorney is here, so if the court wants to continue, we can at this point.
Where's Mr. Black's attorney?
In the way. This is me, Attorney Justin Hill, Your Honor.
Is it Justin Hill?
Yes.
Okay. And you are counsel for, I'm sorry, Mr. Hill, I apologize.
I'm sorry, can you say that one time?
You're counsel for whom, I'm sorry?
Mr. Blaylock.
Mr. Black, okay, all right.
Demond Blaylock, yes.
All right, Mr. Wilson, do you have a copy of the proffer?
I can take a photo.
Could you please, ma'am? I don't think I have it last year. Huh? Oh, yeah. We kind of jumped the gun a little bit, just to, so that myself and Ms. Weaver are in sync as to who is present today and who's representing whom. Can we just take roll call as to who's here? So we'll start out with my left, your right, gentlemen, or ladies. If you're representing anybody, could you kind of state who you are representing, please? Okay, all right. All right. Okay. That was right.
Adrian Love for the state, Your Honor,
Okay.
Deputy District Attorney.
Yes, ma'am.
John Floyd from the state.
Deputy District Attorney Simone Hilton for the state. Assistant District Attorney Lizzie Rosenwasser for the state.
Okay, all right. Now for the defense counsels and their clients. All right, we'll start off, Madam, I forget, and on the right side.
Chelsea Golden for Mouse Farley.
Thank you, Madam.
Anastasio Spinetis for Mr. Mouse Farley.
David Ross, Shannon Stewart. Max Shard for Shannon Stewart.
Keith Adams, Jeffrey Williams.
I'm Brian Steele, I'm also the honor representative.
Okay. All right, counsels in the back, anybody representing anybody here today, Madam? In the orange? Yeah. I'm sorry, one more time?
Nicole Morgan for Companies Group.
Yes, ma'am.
Gina Devon for David Myrick.
Michael Russ for Mr. Bear as well. Good afternoon, Suli Shah on behalf of Mr. Dorsey.
All right, continue to the center.
Doug Weinstein for Mr. Giamonte Kendrick.
All right. Hold on, Mr. Harvey, I think it's you.
With Mr. Nelson, along with Nicole Westmoreland, she is on Zoom, and you can see that she is on the
Yes, sir, thank you. All right,
Angela Lee Williams for Mr. Ryan.
thank you, Madam.
Sean Hoover for Antonio Sullivan.
Okay,
Justin Hill for Demond Blaylock.
all right. Continue, Madam.
Christy Gladden for Trontavia Stevens.
Thank you, Madam. All right, anybody else to my left, your right? Okay, all right. Just want to make sure who was here along with clients today. All right, okay. Thank you very much, counsel.
If I may, I apologize. I'm here on the platform, Tiambra Callan, on behalf of Mr. Khalif Adams.
Okay. All right, anybody else on our Zoom platform? I'm sorry that we had such difficulty with today. Anybody else? Is your client, Mr. Adams, on the platform as well?
He is not that I see, Your Honor.
He's in the back row.
He's in the what?
He's in the back row.
He's here actually in court. He's in the gallery, madam.
Thank you, Your Honor.
Okay, all right. One more time, counsel, your name. I apologize, madam.
Tiambre Calland.
Well, and can you spell that for us, please?
Sure. First name is Tiambre, that's Teombre. Last name is Calland, Calland.
Okay. All right. Okay. All right. Okay. All right. So we're talking about proffer. So Ms. Rosenwasser, do you have that?
Yes, Your Honor, I was able to locate a transcript from a previous hearing.
Okay, all right. So can we take care of Mr. Blaylock's proffer at this point in time?
Yes, Your Honor.
All right, let me go ahead. Mr. Blaylock, where are you, sir? Can I get you to raise your right hand for me, please, sir? Investigator, would you solemnly swear or affirm the evidence you'll give in the matter now hearing should be the truth, whole truth, nothing but the truth, so help you God so affirm?
Yes, sir.
All right, you put your hand down. Sir, we're just gonna ask you a series of questions just related to the proffer, nothing else. And then after that's done, I'll make a decision as to you and your counsel, okay? All right, Ms. Rosenwasser, if you go ahead and read that particular cover, he's already been sworn, so.
Sir, I recognize you're currently being represented by, I'm sorry, your name, sir.
Justin Hill.
By Mr. Justin Hill, is that correct? And sir, were you previously represented by Mr. Sean Hoover? Are you aware that Mr. Hoover is still representing your co-defendant, Mr. Antonio Sumlin? Okay. Now, have you been advised of a potential conflict between this attorney still representing Mr. Sumlin? No one has advised you of a potential conflict?
Oh, yeah, yeah,
So, yes, someone has spoken to you? Okay. Is that your attorney right now has spoken to you about that? Okay, who spoke with you about that? Okay, did a woman, Ms. Rivera, speak with you? I'm sorry, sir, I'm being confusing. Has another attorney, anyone other than these two guys ever come and talk to you about this case? Okay, was it an attorney as far as you know? Okay. Did she explain to you that there is a potential conflict with the agency? Okay. Are you aware of, so you are aware of that conflict? Okay. You understand, that you have had, even if you have had meetings with this counsel, Mr. Hoover, you still have no objection to him continuing to represent your co-defendant? Okay. And you met with someone else independently outside the presence of Mr. Hoover or your current counsel about a potential conflict of interest, is that correct? Okay. And you have stated that you waive any potential conflict and you wish for this gentleman to remain your counsel and you waive any conflict with your co-defendant being represented by Mr. Hoover. Okay. And has anyone promised you, threatened you with anything, coerced you, or in other ways forced you to consent to this? Okay. Do you waive any other potential issues, so including that anything that this counsel has learned from you could be used in your co-defendant's defense? You don't waive that? Try again. Do you understand that if you went to trial, anything that he learned when he was representing you, Mr. Hoover, could be used to help Wait a second.
Mr. Blaylock, did you, before signing that, have the opportunity to talk to counsel to your satisfaction? Yes? Okay. And you give this waiver freely and voluntarily, your own decision to waive any potential conflict in this case? Yes. All right. Do you have any other questions about this particular conflict you want to ask me? Okay, all right, I'm going to go ahead and Mr. Mr. Authorize you to represent. Okay?
Thank you, Your Honor.
All right, thank you, sir. Mr. Rosenbaum, any other waivers that they want to cover for?
I believe that covers all the waivers.
Thank you, sir.
Little sound again. First it sound crappy, now it's no sound. That's why it's gonna be so important for me to be here. They're not gonna televise this to jury part. Nope, they're not gonna televise.
Mr. Hoover, Mr. Plea, what is your representation?
Your Honor, at one point he had an attorney. I'm not sure if that attorney was withdrawn. It was for Larry Hemingway. So I don't know if she is for Larry Hemingway. I don't know if she's withdrawn. I know he had an attorney when I was doing a lot of motion service last month.
From my understanding, Ms. Hemingway still represents Mr. Fleetwood. I'll definitely double check.
I'm sorry, it is not. She works in the same office.
Yeah, I think that was the problem.
I'm not sure if she's formally withdrawn though yet, so that may be why this has arisen.
So, Ms. Bernard, can we do, just a housekeeping matter, can you ask her to, formally, if she's not done so, withdraw? And I will ask Mr. Hoover to go ahead and, continue that process of representation, okay?
Yes, sir.
Okay, thank you, ma'am. All right, so Mr. Hoover, you'll take care of that, and we'll do this.
Yes, Your Honor.
Okay, all right. Mr. Arnold.
Mayor.
Where are you, Mr. Arnold? Good afternoon, sir. Who's your attorney?
Ashley Merchant.
Ashley Merchant. Okay, okay, all right. All right, sir, we're gonna go ahead and, I believe that, she has had something else to do this afternoon, but we've been in touch with her, okay? So just, give me a second. All right, Mr. Beebe?
He's still in call, sir.
Yeah, is he on the,
No, he's not on the platform.
who is his lawyer?
Mr. Partridge has to go to Upson County for another trial today.
Okay, all right. All right, Mr. Eppinger. Mr. Eppinger, you ready to have,
He's right here.
Oh, thank you, sir, I apologize. Okay, Mr. Eppinger, who you represent by, sir?
Eric Johnson.
Eric Johnson.
There was no communication.
Okay, all right, all right.
You know, I have my office reach out to Mr. Johnson, so we will make sure it will be.
Thank you, sir, appreciate it. All right, and this is McMullen. Mr. McMullen. Who? I'm sorry?
Amanda Young, I believe it's in the care of the they're making conflict.
She withdrew, and Attorney W.B. Green will be representing her moving forward. I want to say yes, but I have not double checked myself.
Who is Mr. Montalban's attorney now?
W.B. Green.
Do we have a withdrawal? Who is his prior counsel?
Amanda Young.
Amanda Young?
Yes.
Do we have a withdrawal from her as again?
Yes, the court.
Okay, do we have an entry with Mr. Green?
We do not.
Mr. Who?
I'll make sure it gets done, Your Honor.
Okay, he is doing. Sworn on that, looks like Mr. Green entered an appearance on sworn on that.
Okay, perfect.
Okay, all right. Yeah. Mr. McMullen, I'm gonna go ahead and since your counsel's not here, we do have some, he'll talk with you, but I'm gonna release you at this point in time, okay? Mr. Evans. Mr. Evans, I'll release you at this point in time as well, since your lawyer is not here, Mr. Johnson's not here as well. Mr. Beatty, where are you?
Not here. He's not here.
No, Mr. Beatty's not here, okay, that's fine, thank you. All right.
Order in the court, please.
Mr. Arnold, I'm going to release you to Mr. Burton and then come back and talk to you, okay? All right, Mr. Fleetwood, where are you?
Yes, sir. Trying to see why he's trying to have a lawyer represent me at the last moment. I've been in prison.
You are, I'm sorry, one time you are, sir.
I'm trying to figure out why I got an
You are,
attorney
sir,
trying to
okay?
I'm trying to see why they got an attorney trying to represent me at the last moment. I ain't Fleetwood.
Mr. Fleetwood.
I've been in
Okay,
prison for 5 years. I didn't get no chance to talk to my lady, about it on 24-hour lockdown, sir.
Mr. Fleetwood, I believe that you raised that concern the last time that we talked, and you were on Zoom. And, that is an issue that you can take up with the lawyer that actually gets appointed to represent you. So, I understand, but that lawyer is gonna talk with you about any issues you may have in regards to representation. It's not today. Mr. Who, when do you think we can get him appointed counsel? Because he's very anxious to talk to the lawyer.
I'm working on it right now, Your Honor.
Okay, so, Mr. Fleetwood, they're gonna go ahead and get you a counsel, okay?
I think this young man is saying that he wants to get his own lawyer.
Well, if that's the case, then you certainly is welcome to do so, Mr. Harvey.
Well, I just wanted to.
I understand. And you're welcome to use your own attorney, but you know, this case is indicted back in May of this year.
I've been on till 24 hours a day, not able to contact my family at all, sir. Every time we got on the phone, we told you that you say it was out of your hand.
Well, because I'm the referee. To make sure everybody gets a fair trial. So the issues that you're raising right now, I'm sure that when counsel does get appointed to represent you, they'll go ahead and take that issue up, okay?
I ask you.
Yes, you excuse sir, yes. All right, Mr. Darlington? Yes. Sir, I'm gonna go ahead and, you're gonna get another lawyer, Mr. Darlington, right? So you're gonna get another lawyer, that lawyer will be in touch with you soon, okay? Because Mr. Lewis withdrew, but we'll make sure you get, Mr. Hoover's gonna make sure we get your lawyer appointed, and that person will come talk to you soon, okay? Okay, you'll be released this point now, yes, ma'am. That's fine. All right, Mr. Mender?
Yes, sir.
Mr. Mender, we're going to return you to the table properly soon, okay? All right, thank you, sir. And Mr. Sledge? Yes. Mr. Wright was on a little earlier, I'm going to return you as well. He was on the platform, but we had some issues with Zoom today, so we're going to talk with you otherwise. Okay? Yeah. All right, so I'll release you this time. I'm going to follow forward. Are there any counsel in here who have motions to file, but you are having discussions with the state, you don't want to have any motions today, you just stay home? You can already go ahead and just let me know. Anyone?
I don't know if it's possible for me to do all of my motions today. I'm not necessarily with the state because I'm in a trial. I would like the opportunity to talk to someone before we proceed with my evidentiary motion. That's on behalf of Mr. Nichols.
Oh, I see. Okay, I see. Ladies and sir, is that something you all are, would like to do something?
Yes, Your Honor. We always, definitely, yes.
Okay, Ms. Harvey, that answer your inquiry?
Yes, thank you, Judge.
Thank you.
I'm just here to get my COEs from Mr. Box and Mr. Field.
No, that's not true. He's old enough to where he don't need CM.
That's true. That's true, and so is David. So is David. When you hit 105, you don't need that.
Well, I heard you're saying over 70, you're good, so, yeah. Is that easy? All right, okay. I'll track that. Okay, is there anybody else? That you otherwise not told me you'd like to go ahead and entertain these motions? Ms.
Well, Your
Guy?
Honor, I have a different issue. I was just retained and just filed my entry, so I do not believe that I have any motions pending, but I'm not sure if there were any that were unheard by this council.
Okay, what do you represent, you know, David?
Trontavia Stevens, Your Honor. Mr. Flugel had to withdraw because his wife had a medical issue.
Yes, that's true, and we are familiar with that issue.
Yes, Judge.
I would like, he has several questions, ladies and sir, if he ever rule on any questions that I know we are, some.
Your Honor, some of the motions were ruled on, I think we all of the MERS that, Mr. Floyd handled last time.
Yeah, Ms. Glenn, I've got a couple of, he's got a motion to testimony
I'm sorry, Judge, maybe not hearing it.
one more second, one more, let me get on the record.
Thank you, Judge.
There is a motion to limit the testimony to facts stipulated in the plea colloquy. I don't believe we've taken that up or taken that issue. I know that we ruled upon the special demurs as to count 1, acts 48, 49, 50, 52, 53, and 54. And the special demurs to count 1, acts 127 and 132. Mr. Floyd, did we take up anything else in regards to as it relates to Mr. Stevens? I believe that you argued and I ruled upon those particular motions the last time we were here, sir. Is that correct?
The ones that you just described, Judge, yes, you did rule on, you denied them.
We will certainly entertain you at some point in time, okay?
Indeed, thank you, Your Honor.
Okay, all right. Anybody else? Okay, all right. Ms. Love and Mr. Floyd and Ms. Hilton and Ms. Rosenwasser, and counsel, it's all of you, I know that we were supposed to take up the jury questionnaires. I think I'm going to not take up those issues today. I'll wait until probably Monday or Tuesday of next week. Since all the lawyers are not here, most of them will be here probably on Monday or Tuesday, and resolution may affect some of those particular folks. So I will wait on that. I'll table that, but I'll hold that for just until such time. Counsel for the state, are you engaged in any comment? I know that you're supposed to begin your motions for the Daubert and 702 issues effective as of Monday. How is that coming, Ms. Rosenwasser?
So, Your Honor, we have we provided on last Friday a list of, everyone we're expecting to call as a expert witness with what we're going to qualify them in. We have provided CVs, in Dropbox folder, I believe, and don't quote me, I think the list is at about 27, 28 people at this point. Some of our witnesses are only available the first week, some are only available the second week. So we would just ask that the court honor that. And additionally, Your Honor, we believe that only one or two witnesses will need to testimony via video conference. Only one defendant objected to that, and that defendant is no longer on this case. So we anticipate almost everyone's going to be live.
Okay.
And we may have some amendments, but we will let the court know if there's any additional people we're going to call.
Okay, thank you. And that's a good update. What I was going to just is ask if there are any negotiations or other pleas that may be taken from this particular case that I don't know which defendants are interested in that, but that might be something that should be considered and discussed. I'm available tomorrow afternoon, and I was going to see if that could be taken on Monday. For those particular, Monday is the 19th. Since we're going to be here all day, if we could utilize some part of that day, Ms. Rosenwasser, if you would be so kind as to send those who are left an email just outlining which particular witnesses you'd like to call on which days, that would give us some roadmap.
Absolutely, Your Honor. We don't know how long everyone's going to take. We anticipate some days it may not take the whole day, some days it will. We have one witness coming on Monday that can only testify. That's the only day she's available, but I think everyone else. We just ask that some of our people can be, if they're close by, could be placed on call. But other than that, we have everybody here, and we'll send out an order to the court, in order to people can call on which days on Friday. I can do that.
Yeah, and the other thing I was going to just point to everybody's I know my order says the 19th through the 22nd. I think that we in the county are off on the 23rd. Is that correct?
Yes.
And then we are also off on the 26th.
Yes, Your Honor.
Yeah, so I made a mistake as to that, as to our availability, so just adjust your schedules accordingly.
Yes,
All right, okay. All right. Edward. I got my pen. Do we have anything? Ms. Callen?
I'm here, Judge.
Callen, do you still have, you still wish to hear any motion to dismiss and, motion to suppress?
Judge, I did file a motion to suppress on December 5th.
Hey, lady. Watch this mess. What mess? Stuff. What mess? That YSL stuff. Oh, oh yeah. Child, that's a mess right there. You see all the chains and stuff in there.
went to trial in DeKalb County and was otherwise found guilty. Is that correct? He's under sentence?
That's correct.
All right. What's your pleasure, sir? I mean, I know that you have a few motions that are pending, but what's your pleasure on that? Do you wish to talk to the state, or what do you think? Thoughts?
We are in discussion with the state. I hope that an offer that my client will accept will come through. At this point, I'm not at the benefit of talking to my client because he's been moved. Hopefully, once I get an offer, I can present it to him. Otherwise, we'll be ready to go forward on motions on 19.
Okay.
So, no, he will not be here on Monday. He's currently probably in process into GDC. And once he's processed in, I'll get notification. And then I can start the process to bring him back to Fulton. So it may be one day next week or possibly before trial.
Yes, sir. So we'll go ahead and do the same. If the kids come on Monday, Mr. Chamberlain is trying to work that issue with again, we got to go through GDC and probably success and everything else. So we're going to see if there's anything we can talk to that state.
No, we completely understand all the logistics. We're not trying to rush anything.
Oh, yeah.
We'll deal with it with you guys.
Okay. Thank you, sir. Appreciate
Thank you,
it.
Your Honor.
Yeah, we have business, and if you want to stick around, it's fine. If I want to be excused, that's okay too.
I'll stick around for a minute. Thank you, Your Honor.
Okay. Okay, Ms. Menez, did you rule on some of your motions already?
Yes, Judge. No, Your Honor, we only had addressed bond. And then I did have another motion about bond as well, but I had filed about, it was like 21 motions, so I think only 18 of them are required, and only 3 of them are required in witnesses. Yes, you have. I think.
Mr. Weinstein.
Yes, Your Honor.
All right, we don't have anything else to hear from you for the time being. We're going to table your motion. We're going to table your motion, correct?
That's correct. We also have a motion regarding the rap lyrics, but obviously that will wait till
the
whatever date that is.
So you're welcome to stay, you're welcome to, Mr. Kenny, still with you?
Yes.
Okay, so you're welcome to either stay or to proceed on Monday.
Thank you, Your Honor.
Okay, all right. Mr. Nard? Madam, you still representing Mr. Myers, correct?
Yes, Judge.
Now, you don't have any motions at this point in time, but are you going to file some?
Yes, Judge, I will.
Okay, so do you wish to remain, or do you want your release?
I'm gonna remain because I actually joined it, that's what I adopted.
Okay, all right, okay, I just want to make sure, okay, you're good.
Thank you.
All right, we'll see you again, I'm sure on the 19th. All right, okay. All right, we're here with Brian. All right, Ms. D. Williams, sorry, ma'am, sorry, we appreciate you being patient with us. Do you have any other motions at this point in time now?
No, Your Honor, I don't have anything right now.
Okay, do you and your client wish to remain, or do you want to, we'll see you on Monday?
See us on Monday.
All right, and have you had an opportunity to talk with the state?
No, Your Honor.
Would you like to do so?
No, thank you.
Okay, all right, just want to make sure, change your mind, let us know, okay, but we'll see you on Monday.
Thank you.
Okay, all right, so Mr. Ryan, we'll see you on Monday, okay? All right, thank you, sir. Attorney Legislature, Mr. Wright, we'll see him on Monday, I guess. All right, and try to check in with Mr. Stevens, we'll see them on Ms. Gladden, we'll see her on Monday. Yeah, but she has some motions right now. She's gonna table it for a time being. Ms. Gladden, are you gonna be able to join us on Monday?
Yes, Your Honor.
Okay, all right. Thank you.
Thank you, Judge.
Okay, all right. Okay, Mr. Short, Mr. Botts, are we gonna see you all on Monday? I know we're gonna.
Yes.
Okay, all right, so, but I'm continuing or otherwise pursuant to your, request, your motion to dismiss and motion to suppress.
Okay.
Is that correct?
Yes.
Okay, all right, okay.
Okay, on, Mr. Jackson.
Mr. Yes, Mr. Jackson, do you have anything else from Mr. Jackson that you want?
We do, I don't know exactly what you're asking me. We do have pending motions.
Such as, I thought we,
Well, for my question is, we're done with
closer to trial,
Absolutely.
or before that particular evidence is supposed to be admissible?
Yes, Your Honor, and I'd imagine I'm not the only party that's going to be interested in that.
Okay.
We filed a motion in limine that kind of complements that motion. We kind of said, okay, so we responded out to this. We also have the state's motion in limine to admit co-conspirator hearsay, which is related to that motion. So we'd be asked that they be heard at the same time.
Okay. All right. So I'll table that for the time being. What about your motion to dismiss the indictment, motion to, amended motion to dismiss?
I have it, those are on constitutional speedy trial grounds. It's going to be a bit lengthy, in all candor to the court, but I'm at the court's pleasure. I will also inform the court that I do need to speak with the state because there are specific photo lineups that were presented to a witness that I'm unable to find in the discovery, and I'm not attributing blame to the state, but I need to figure out where those are because that's going to be an issue regarding a witness as well.
Your Honor, I'd ask that the court allow us an opportunity to speak a little bit further to flesh out those issues with Mr. Sharp and to have his motion to dismiss based on constitutional speedy grounds heard at a date later than today.
Okay. All right. Okay, that's fine.
I'll send you all.
Mr. Hoover? As it pertains to Mr. Sullivan, didn't we take care of your motions already?
Most of them, Your Honor.
Yeah, which ones left?
Well, the majority of them have to do with, after we get done with the 702 hearing, so that's not an issue right now. The state is trying to use two of my clients' priors against them, so we will have to take that issue up at some point. And other than that, I just have a motion in limine that we can talk about once we get close to the trial.
Okay, all right, so you're covered, all right, just want to make sure.
Yes, sir.
Okay, all right. Where's Mr. Rubin?
He's not here, Your Honor.
Obviously. Oh, when he leave, where's,
I think he's sent an email to Mr. Kern in the court.
Mr. Kern, do we know anything about Mr.? Okay, all right, I understand. Okay, I just wanted to account for him. All right, no problem. Okay.
On behalf of Mr. Sullivan, I would like to state, but Mr. Sullivan has expressed that he does not want to, and I'm okay with him not being here for it.
Oh, you're gonna waive his presence?
Yes, Your Honor.
Mr. Sullivan, you okay with, your lawyer, just being here for purposes of any other things that might be of interest to you?
Yes, sir.
I'm sorry?
I said, yes, sir. I don't have to use it.
Oh, fine, okay, yeah. Do you want to come back after you use the restroom or what?
Yes, sir, I wouldn't come back. I just had.
Okay.
One person.
That's fine, I'll wait, I'll let him wait his presence for the time being. All right, Edward, I think that we're good. I think that what I'm going to do let me take up. I don't think there's anybody else that can take them out. There's one more. Witnessing it.
Would like to also be excused at this particular point. This is back starting like mine.
All right, sir, I have, assuming that you were waiving his presence, that's fine. I don't think I'm gonna go much longer. I'm gonna probably, I think I have to take it with one witness from the state. Is that right? And I think that's it I think that's gonna be it for today. We got a little bit of a late start due to technology. It wasn't anybody's fault, but, just so we can kind of, move accordingly, that's what I was gonna do. So, Mr. Menez, I'm gonna hold off on, are you having discussions with the state, sir? Mr. Menez? Are you having any, I'm gonna hold off on your motions because I've kind of run out of time and space for today. But, are you having any discussions with the state, sir?
Not any more than a regular case should. So we haven't gone anywhere, we haven't offered anything. So we'll, at that, go ahead.
Ms. Love, Ms. Hilton, have you had discussions with Mr. Menez?
Your Honor, we had a conversation with Mr. Menez last night. At this point, we are still in conversation, and we would like to have a conversation.
Okay.
And just with regard to the conversations about a plea that doesn't involve any type of collaboration.
Well, I don't need to know anything about that. And that's up to you and your client. And certainly, I don't want to violate any attorney-client privilege, but that's certainly up to you, sir. And whatever you can negotiate with the state, if that's the case, I'll let you all finish those discussions. Okay. All right. Okay. All right. Do you wish to waive your client's presence?
No, Your Honor, he's going to stay seated.
Okay. All right. All right. All right, State, go ahead and call your witness, so we can go ahead and take this.
Thank you, Your Honor. We're going to call Agent Raisi to the stand.
Agent who?
Raisi, R-A-I-S-S-I.
You okay, Christina? Do you need her? Are you Agent Rahisi, sir?
I am, Your Honor.
All right, good afternoon, good evening, sir. If you could please approach the witness stand once you get there, if you'd be so kind to turn and face Deputy Talton, sworn as a witness, please.
You swear the firm testimony to the court, all truth, nothing but
I do.
state the story,
It's David, D-A-V-I-D, last name is Raisi, R-A-I-S-S-I.
And good evening, Agency. Where are you currently employed?
The Bureau of Alcohol, Tobacco, Firearms, and Explosives, commonly referred to as the ATF.
And how long have you been with the ATF?
About 2 years.
Prior to working with the ATF, where were you employed?
The Cobb County Police Department, Georgia.
I'm sorry.
Just was making it clear, Georgia.
And how long were you with the Cobb County Police Department?
12 and a half years.
What was your last assignment with the Cobb County Police Department?
I was assigned as a detective to the Crimes Against Persons Division and also a task force officer with the ATF.
And how long did you serve as a detective within the ATF?
6.5 years.
I want to take you to July 2015, where you worked with the Cobb County Police Department.
I was
And what capacity was you working with the Cobb County Police Department?
a detective in the Crimes Against Persons Division.
And during this period of time, did you have the occasion to conduct an interview with Jeffrey Williams?
I did.
And where did you conduct that interview?
I was at the Cobb County Jail on Memorial Drive.
And do you see Mr. Jeffrey Williams in the courtroom today?
I do.
And if you can identify him by article code of that email.
He's sitting to my right at the defense table, a third gentleman over, wearing, it looks like a dark colored jacket, white shirt, and a tie. The third subject over.
Your Honor, let the record reflect that Agent Rice has identified Mr. Williams.
Yeah.
And why did you want to speak with Mr. Williams in Cobb County?
We had a shooting that occurred in Cobb County, April 26th of the same year, and we believe that Mr. Williams may have some information or be involved in that incident.
Now, you work for Cobb County, but you was in the DeKalb County Jail.
That's correct.
Do you know why he was in the DeKalb County Jail?
He was arrested, reference to a warrant out of DeKalb County.
And when you went to the DeKalb County Jail, did you ever speak to him about his DeKalb County case?
No.
Now, when you went to the interview, were you there with anyone else?
Yes, I was.
Who was you there with?
A special agent with ATF, Tyrek Cunningham.
And why was Agent Cunningham with you for this particular interview?
The ATF was involved in a larger investigation, and she was one of the representatives that were there. And I got in contact with her just to see if I could go to DeKalb County and interview Mr. Williams in reference to my case.
Now, when you went to DeKalb County to speak with Mr. Williams, were there any warrants for his arrest as related to the Cobb County incident you were investigating?
No.
Was he a suspect in that Cobb County?
No, not an official suspect, just potentially involved person or someone that would have information for us.
And when you went to the DeKalb County Jail, were you able to speak with Mr. Williams?
I was.
And did you read him his Miranda warning before you spoke with or interviewed Mr. Williams?
Special Agent Tyrek Cunningham read him his Miranda warnings, but yes, I was present when that occurred.
And why did Agent Cunningham choose to read Mr. Williams his Miranda warning?
Objection. Speculation.
Did you all have?
Okay, I'll stand objections to form. Go ahead and rephrase, please, ma'am.
Did you and Agent Cunningham have any conversations prior to going in about reading Mr. Williams' Miranda warnings?
Yes.
And what was your reason for wanting to still read Mr. Mr. Williams' Miranda warning?
He was in custody and we were going to be questioning him. And we were law enforcement, so.
And again, he was not in custody pursuant to what you were investigating in Cobb County.
That's correct.
Now, when you began interviewing Mr. Williams, did he appear to understand English?
Absolutely.
Did he appear to be under the influence of any drugs or alcohol?
No, he did not.
Did he appear to be coherent?
Yes.
Did he appear to be sick at all?
No.
Did you give him any promise or hope or benefit to get him to speak with you?
No.
Did you coerce Mr. Williams into making any statements with any threats or actions?
No.
Did you hold out the remotest fear or injury to get him to speak with you?
No.
Now, you can tell the court a little about your style and how you interviewed Mr. Williams.
This interview was non-confrontational, more of like a conversation interview. Mostly just about background information. It wasn't directed towards any sort of particular crime until the latter
I'm gonna first show you what's been marked as State's Exhibit 5 NJW. Tell me if you recognize State's Exhibit 5 NJW.
I do.
And how do you recognize State's Exhibit 5 NJW?
This is a advice of rights and waiver form, commonly referred to as a Miranda form, that the U.S. Department of Justice, the ATF, utilized, and it's what we utilized on the day in question.
And is that the form that you went over with him?
That, yes, we did, jointly, yes.
Is this a fair and accurate copy or depiction of the form that you went over with Mr. Williams back in July 2015?
Absolutely.
Your Honor, this time to say like a tender State's Exhibit 5 NJW into evidence.
Any objection, sir?
Not for purposes of today's hearing, Your Honor.
Okay.
Standing for the next one.
All right, State's 5, MJW is admitted for purpose of the motion.
Okay, and I'm also going to show you what's been marked as State's Exhibit 4 NJW. Do you recognize State's Exhibit 4 NJW?
I do.
And how do you recognize State's Exhibit 4 NJW?
I reviewed and listened to audio on this disc this morning, and I initialed and dated the disc.
And that appears to be the full interview that you had with Mr. Williams back in July 2015.
Yes, there are 2 files, full interview.
Okay, Your Honor, this time to say you also like to tender State's Exhibit 4 NJW into evidence.
All right, no objection?
Right, for the purpose of
Purpose of the motion. So State's 4 MJW is also purpose of the motion.
Thank you, Your Honor. Now, Agent Rice, if you can go through from beginning to end the State's rights form that you did or completed with Mr. Williams back in July 2015.
Yes, ma'am. You want me to read the top to the bottom of every word?
Top to the bottom.
Okay. U.S. Department of Justice, Bureau of Alcohol, Tobacco, Firearms, and Explosives, Advice of Rights and Waiver, and it's titled Statement of Rights. The first bullet point is you have the right to remain silent. Second bullet point is anything you say can be used against you in court. The third, you have the right to talk to a lawyer before we ask you any questions and to have a lawyer with you during questioning. Fourth, if you cannot afford a lawyer, one will be appointed for you if you wish before any questioning begins. And the fifth bullet is if you decide to answer any questions now without a lawyer present, you have the right to stop answering at any time. Next is a waiver. It says, I have read this statement of my rights or have been read to me, and I understand these rights. At this time, I am willing to answer questions without a lawyer present. No promise or threats have been made to me, and no pressure or force of any kind has been used against me. Then there's a signature line, a printed name line, a witness signature line, a printed name line, a date and a time, and then a note at the bottom margin, note, and the 1204, that was revised September 2005.
And that is the form that you went over with Mr. Williams back on July 15, 2015.
Yes, ma'am.
Was Mr. Williams ever arrested as it relates to the Cobb County shooting you were arrested?
He was not arrested.
Did you ultimately arrest someone as it relates to that case?
Yes, we did.
And who was that person that you were arrested and charged in that incident?
Jimmy Winfrey.
Your Honor, this time the state would like to, they can do it now or they can do it later, publish State's Exhibit 4 MJW, the relevant portion, Your Honor.
How long are we talking about in terms of?
Probably the relevant portion, at least for this witness, would probably be about 7 minutes.
Okay. All right.
It is obvious.
All right, go ahead. Get it. Go ahead and play it.
Yeah, the total. Well, the total you were, Mr. Steele's correct. The actual portion is about 10 minutes and 45 seconds. Is that okay, Your Honor?
Okay.
Your Honor, or if anyone would access, we can share, share capabilities for.
I don't know if I can do that from here.
West, you have the ability to do that?
I know there's a CTS on the screen on the center.
Who?
Can we get, those of you who may be on the Zoom call from IT, can I get you to please authorize screen sharing for our district attorney, please?
Okay, who said that for us? Okay, all right, go ahead.
I think she said 5.
Can I possibly use the bathroom? Thank you. Yes. For sure. Right.
was trying to read slow. Yeah. It's like, you need to go slow so I don't just.
Right, so as you know, we're trying to get a Bluetooth speaker and hopefully see this one.
Well, is it possible we can use, you're trying to put that in your speakers on your computers?
Yes, because we can't put this in the system so the court can hear it. The microphone.
Yeah, let's go to Mark, let's see if we can kind of make that work. We've done that before.
I think it's working in full. You got it. Just share screen. I'll wait. Sure. That's fine.
Oh my God, you're still doing this? Watching it?
Excuse me, if you want to share your screen, you need to mute your laptop's microphone and your laptop speaker.
Now we're
You
looking
won't need
like
that.
we're looking at the ground, y'all. What the heck is this?
Is it working, Miss Hill?
Thank you.
What time the judge going home? Oh my God. The judge going home. Boom.
Hello, is this Simon Hilton?
Ms. Hilton is going to be right back. So you want to talk to them? Adrian, do you want to talk to this?
She's coming right now.
What do you need us to do? Hello?
Hello, yes, so my name is Ade, I'm from Core Technology. I would like you to please reshare your screen so that the sound can come out properly. Please stop share. Hello, I need to follow my direction.
Just one moment. You need us to stop the share.
Yeah, for a quick yes.
All right, okay.
Good, so next time you click on the share screen button, please, there are two check boxes underneath the window. One of them says share sound.
They would check and we will check them again if you'd like.
You were checked?
They were checked.
Oh, okay, thank you.
Now, we can take out and optimize the video clips since that's not.
You can leave that. You can leave that, that doesn't matter.
Do you want me to test it this way?
I don't think it's but it's more. That's fine. I mean, it was working before I I think we can work with, Agent Rice's schedule in order to, finish the rest of the show.
Okay, all right. Mr. Steele, if it's okay with you, we have some other, administrative concerns about the personnel that's involved in the day. And it's at 7 o'clock. As much as, I'd like to be and discussion might be the better part of just putting a pin in for today and us picking up for this at that time.
Understood.
Okay, all right. So, Agent Reese, the state will go ahead and arrange for you to come back on a particular date and time, and we'll take up your testimony at that point in time.
Yes, sir.
Okay? All right, thank you, sir. Don't discuss your testimony with anybody except the attorney in this case, okay?
Yes, sir.
All right, thank you, sir. All right, let me go ahead and just for the purpose of the record, just put on the conversation I had with Mr. Steele.
There go the audio, Coochie. There go the audio.
Thank you.